No
Uh,
steps, nothing has been taken.
yes, sir. So this matter unfortunately has come to my attention only now, sir. Sir, there could be a case where if a building permission is permissible to a certain extent, maybe in the initial permission, the petitioner might take only a portion of it, and subsequently it can be extended to the maximum limit, sir. And
But
thereafter
for
also,
that, are we to understand that it is permissible on the basis of the area, a G+2 can be made to G+7, but without a permission being given by the GMC, you will permit from G+2 to G+7? If we are
sir,
there, then kindly file an affidavit. We will take note of that the permission of the GMC is not required in future if it is permissible as per the land.
Sir, I will only be able to state very clearly once I go through the record, sir. We are in the process of reconstructing the file. We have asked for the documents from the petitioner, sir. But as I see, this permission, this building was given permission way back in 1998, sir.
So that
During
is
that
only
time,
G+2.
T+2, yes, sir. And so that time, the maximum permissible floor area ratio used to be 300. That means up to 3 times the floor area the building could be constructed, sir. So unless we see the document, sir, it cannot be very clearly stated, but it could be the case that of the maximum 300, the petitioner at the initial go might have taken lesser FIR and subsequently has gone ahead and constructing and utilizing the other FIR, sir. And when he applies for regularization, sir, there is a penalty taken. Thereafter, the regularization is done, sir.
Just 3,000 square feet.
Sir?
The land area is only 3,000 square feet.
Yes, sir. So that time the permissible FIR is 300. So we have to, sir, check. Now we have already served a document asking notice to the petitioner again, sir. There has been some litigation in the past as well, as I see that lower court has given an injunction till 5th floor already.
Not even an injunction against 6 and 7.
Exactly, sir. That is what we learned from the court records, sir. We have unfortunately no file with us currently, sir. We are in the process.
Litigation has been going on for the last 8 years. You don't have a file records? Isn't
So
it
we have the legal
surprising?
records with us, sir. We have the court case records, but we do not have the building permission records. Unfortunately, we see that the erstwhile AP in May of 2023 have also filed an FIR stating that the file has been missing, sir. In the last couple of years, sir, unfortunately, our office have been moved a couple of times, sir. From Pan Bazaar, we went to some other place.
Mr. Officer, that happened in 2019. We are in 2024, 5 years down the line.
Yes,
What
sir.
have you done as regards that?
So this matter has unfortunately come to my attention only now, sir. So we will look after it and we'll take care. We'll take necessary action as per the directions of the court.
Your presence on this Thursday, 10:30. Get your details. Thursday.
Yes, sure, sir. We have asked for the document from the petitioner, sir. We will
I'm
get
not
the.
concerned with the petitioner. The question is, does GMC, if the GMC does not have, are we to understand that nothing can be done in respect to a violation to the building bylaws as well as the GMC Act?
It can be, sir. That is what, so we are in the process of reconstructing the file because the
So
petitioner
you
will, of
woke
course.
up so late.
Sir.
You were supposed to take action 8 years back, but because of that, the writ petition had to be filed because you were not taking any action. Even you had issued a notice under 337. Means not you, your predecessor had issued a notice under 337. Thereafter, what has happened? The
Yes, sir.
file, how did the file get lost when you have taken an action under 337? Isn't it a very strange thing? Should we inquire, give a CID inquiry in this regard? It is very strange because I would have understood that there is no issue, nothing, it's going on like usual, and as such, you may have lost the file. But when you have taken an action under 337 by issuance of a notice, how does a file get lost? Some person in your office must be doing something, otherwise it can't happen.
Yes.
We have
So we will.
the matter again on 18th of November. Get your facts ready.
Sir, yeah, right. Sir.
18th of November at 10:30 a.m.
My lord, one thing, my lord, I have been never asked to supply any kind of document. He's saying the respondent. Respondent. The respondent.
It's okay. Let us ask the GMC. Because if tomorrow the GMC commissioner comes up and says that if we lose a file, then there is no requirement of any going into any deviation or any violation to the building bylaws, or for the purpose of going into the question of uh, any violation to the act. Not necessary. Very well. We will take into consideration that and ask him to put it on affidavit, so that in future, all matters which are being taken up in regards violation of the GMC bylaws, we are going to say that no, you cannot take any action out there. Let us see
This cannot.
what the GMC commissioner has to say. First, pursuant to the order dated 7/11/2024, Mr. So-and-so, what is his name?
MN Dahal.
So-and-so, the commissioner GMC is present in the court through the video conferencing link provided by the standing counsel of the GMC. First, the commissioner GMC submitted that as he had only arrived yesterday, he does not have the materials to make appropriate to place the appropriate. He has submitted that he does not have he has to go through the file, and as such he sought for some time. So taking into account the above, lists this matter again on 18th of November 2024 at 10:30 a.m. on which date the Commissioner GMC shall again be present through the video conferencing link to be provided by Mr. P. Naik, the Standing Counsel of the GMC.
Thank you, sir.
This court also takes notice that the Associate Planner Guwahati Municipal Corporation had also issued a notice on 6/11/2024, a copy of which was furnished during the course of the hearing by the learned Standing Counsel of the GMC. Full stop.
You have received it on 8th. You have received that notice on 8th.
Mr. Jed Mukit, appearing on behalf of the respondent number 5, submits that that his clients have received the said notice and are taking appropriate steps for furnishing the details.
Instead of 15, my lord, can it be on 21st, my lord?
Absolutely no.
Because
18 days, 18. I'm Mr. J.L. Borguia.
I,
Irrespective of you were there or not, I have taken up the matter.
no, sir,
And your junior is capable enough, and
Last-
I am not concerned. Should I direct the registry to strike off your name from the cause list? Don't come up with this type of.
One top of the list.
On the last occasion, this honorable court has directed me to file an affidavit in opposition on 39/2024, your lordship. But I have received instruction, but my department officer was, concerned department officer is not available, as instructed by the department yesterday. I'll file today because the department officer will join today, your lordship. The officer who is concerned on this case.
The matter relates to time barred assessment, lordship. Under the Service Tax Act.
I have received instruction.
Last date also he placed the instruction before the
Yes.
honorable court. Lordship, what happened is that after the SOCOS notice was issued to us in the year 2020, they adjudicated the SOCOS notice after 4 years in the year 2024.
There's another requisition there, na? What happened to the other one?
Lordship, that is still pending.
There I didn't pass any stay order. Where is that? What is the number? Give it to me. I will dismiss one, allow one.
Lordship,
We have not filed your affidavit, so we will construe. No, absolutely no. We'll construe that you have nothing to say. Go before the division bench and file your affidavit.
If, although today he will join the lordship. That is the prayer from the department.
Was he absent from 39? What type of leave is that? Of an officer? Please,
Instructed your lordship to send my affidavit in opposition.
we construe that you have not filed it. So nothing, we allow the requisition. You have not filed your affidavit.
As you know, one day.
The matter was directed to be taken at the top of the list. Isn't it necessary? We asked the presence of that officer concerned.
I beg to apologize.
No,
Only
we'll
one day
see.
it may be given because taking
Tomorrow. Tomorrow, we see the presence of that council officer. That this is the way in which it is done. I'm going to put it up also in the CDBT, na? Central, uh, Central Bureau of Direct Taxation. We'll put it out there that this is the manner in which the Central Excise Department, Central Excise? Yeah, Central Excise Department is functioning. They are not intentionally filing their reply.
The instruction is with me, Lord, but unfortunately, the instruction which have been given to me that I have been reported as completed.
Okay, that can't happen.
Otherwise, your instruction is there, Lordship. I had also sent my instructions to the
We do
department.
one thing. We issue rule. We have not filed it. Issue rule. Make the stay absolute till the disposal of the petition. Now, Mr. N. Havelia, the learned, heard Mr. N. Havelia, the learned counsel appearing on behalf of the petitioner. First, this court, by the order dated 2/8/2024, directed the state respondents and the respondents to file the affidavit on or before 30/8/2024. First, thereupon, the affidavit was not filed, for which this court, by an order dated 30/9/2024, directed again that the affidavit be filed by 4/11/2024. So it is surprising that when the matter pertains to the question of huge amounts of revenue, and it's surprising that when the matter pertains to when huge amounts of revenue is at stake, the respondent authorities, more particularly the respondent number 2, 3, and 4, have not taken any steps for the purpose of filing the affidavit in opposition. Full stop. It seems that the said respondents are not, it seems that in spite of there being a stay order, the said respondents are not inclined to file the affidavit for reasons best known. Full stop. Considering the above, this court admits the instant writ petition, taking into account that the petitioner has been able to make out a prima facie case in the instant proceedings. Full stop. Rule is issued, issue rule. So as the parties are duly represented, no extra copies is required to be served. Full stop. The list this matter for hearing in its usual course. Full stop. The interim order passed earlier shall continue till the disposal of the writ petition.
Supplementary item 64 or motion.
Again, these matters have come back to me. Why? Is court number 5 not sitting?
Yes. Court number 5 is sitting. The other two matters have come today.
This is the matter, and this court is not presently taking up this roster, this matter before the appropriate court.
Item 67, 68. 67,
65. No, 64 to 67.
64 to 60.
Replay.
Again, this matter has come. Take care of the
Item two, order no stay.
None appears on behalf of the petitioner on call. It further appears that in spite of specific directions being issued by the laws of the court, no steps have been taken. It seems that the petitioner have lost interest in the petition for which the instant petition stands dismissed for non-prosecution.
Item three,
Yes.
Lordship, we have taken steps on Friday, Lordship.
What is your case? What about that? What is your case?
Evicted the petitioner from his own plot of land, Lordship.
Huh?
Evicted the petitioner from his own plot of land, Lordship.
Your own plot of land.
Lordship,
Why did you evict? Yes, what is your stand? Was there any notice issued?
oh no. Lordship, yes, notice was issued, Lordship.
Where is the notice?
24/8/22.
Age? Age? Where is the notice? Is government land,
No, Lord.
your land?
Yes, Lordship. Jamabandi is at page 15, Lordship.
Where is the notice? Yes, Mr. Angusame, where is the notice? You said that there is a notice. What notice is this?
No.
Tell, how can you evict? And where, what is your instructions?
Second document. Second document.
We'll have it next week. Get your instructions.
Lord.
This- Why you are making these other people a party unnecessarily?
Lordship, actually,
These 5, 6, 7, 8 unnecessarily. Don't make these people unnecessarily. I mean, the petitioner herein is aggrieved by the action taken by the revenue authorities to dispossess the petition at the instance of some private respondents. This court inquired with the learned counsel appearing on behalf of the district administration, Mr. N. Goswami, as to whether such action as regards the instructions pertaining to the matter, he submits that that there has been no instructions provided taking into account the above. This court fixes this matter on 20/11/2024, on which date Mr. N. Goswami shall take appropriate steps shall place before this court the instructions from the district administrations. Yes, Mr. N. Goswami,
not visible. Tomorrow.
not tomorrow. This court fixed it today. Only one instruction was required as to what steps have been taken pursuant to the order passed by this court on 1/4/2019.
We have sent the letters, Lordship, but
We'll have it at 2 o'clock. Get your instructions.
item five and six, Statement of the petition.
What is the matter about?
My lord, regarding a settlement of the mineral concessions.
And how is he involved?
No, he's not, he doesn't have any locus mineral. That is our objection. My lord, there's just stay order passed by this honorable court.
What has happened, your lordship? What has happened here, your lordship? In fact, your lordship, an e-auction notice was issued on 8/7/2020, your lordship, where writ petitioner opposite party number 1, lordship, got the settlement, your lordship. And he, your lordship, after that, your lordship, he was supposed to deposit the security money within 45 days of issuance of LOI. LOI has also been issued, your lordship. And when that was not submitted, you will not deposited, your lordship, will file a writ petition before this honorable court, your lordship. For your lordship, passing his LOI. Now, honorable court was pleased to grant a stay order in respect of that, your lordship, LOI, your lordship. And after passing an interim order during the pendency of that particular case, the honorable, the authorities of the forest department, your lordship, they have cancelled their LOI. Your lordship. That
She has been challenged here.
in the writ petition, your lordship. There is no stay order as such, your lordship, initially, and thereafter, your lordship, they have issued a fresh e-auction notice. And we wanted to participate in that e-auction notice, your lordship. And that e-auction notice was sent by way of an interrogatory application. And that e-auction notice was stayed by this honorable court by an interim order, your lordship. And thereafter, matter is pending as such, your lordship. At that-
This matter is, there are two requisitions.
Two writ petitions, my lord. One is Ajit Nath
7635
Two-
two Mahajan.
and 7645.
I am in Ajit Kumar Nath.
Ajit Nath, there is a development. Ajit Kumar has preferred a appeal before the PCCM. He wants his deposit back. If he undertakes, if that deposit, if is returned to him, he will withdraw this case.
Who is Ajit Kumar Nath?
Petitioner, my lord.
Yours.
He is the beneficiary of the.
So he
e-auction.
wants this money.
He has admitted that there was delay, my lord, in depositing the money.
How much money does he want?
Well, the letter reflects almost to the tune of 10 plus 15% of the 25% of total settled amount, along with 1 month's rent.
Okay, we take up the requisition for disposal.
Yes.
What is this blackmailing tactics?
And as regards Forest Roy, my lord, Forest Roy has expired. The second petition, my lord, second petition, he has expired.
Who?
The Paresh Kumar Roy. So, my lord, yes, he expired. Since, my lord, it was an individual settlement, my lord, it has to pass on the right exhausted with the petitioner itself, my lord. It has to, neither it was a farm, neither it was a family concern, my lord. So there was an objection raised by me, my lord, that whether their legal heirs can continue with this settlement.
So we take up the matter for disposal. Where is the question of blackmailing? Yes. Again,
I can. A very short point is involved. Basically, it's a case of waiver. It's a fact. I was supposed to deposit within a particular time frame, but thereafter they have accepted. By accepting, my lord, they have relinquished their right to object. That's our case. Now, if your lordship should kindly come to my lord, page number 62, my lord. Page 62 in 7635. This is the provisional letter of intent. Subject to the appeal provision and other provisions of Assam Mineral Concession Rule and other applicable laws, and in pursuance to PCCF Head of Forest letter dated so and so and communicated by dated so and so, you are hereby given provisional letter of intent being successful bidder in respect of so and so for a period of 7 years for a quantity of so and so at your offered price of rupees so and so. The mining contract area falls under B2 category mining, and you are hereby requested to submit the documents like mining plan, environment clearance, and get it approved within 45 days from the date of issue of this letter. The final letter of intent will be considered after fulfilling the above condition as laid down in memorandum issued by the Minister of etc. Then pursuant to this, my lord, at page number 63, petitioner deposited 15%. No, sorry. By this letter at page 63, the petitioner was requested to deposit balance 15% of the, my lord, say balance security. My lord,
You were requested to deposit 15% of the
10%, my lord, along with the
as
bid we have
security
given.
along with additional
Yes.
amount equal to 1 month's contract money.
Yes, yes.
So you were asked to. deposit
Yes, yes, my lord.
around-
Then what had happened, my lord, COVID intervened, there were several letters were there. Eventually, if a lordship kindly comes to page number 67, my lord. This is a letter by the petitioner. With reference to the subject cited above, I have the honor to inform you that due to COVID-19 pandemic and SOP issued by Government of Assam and poor condition of business, I am not able to manage the money as well as prepare bankrupts. So I cannot submit the security money. So in this regard, I ensure that security will be paid by 15/7/21. Therefore, I request you kindly to consider my prayer. Then, my lord, at page 68, petitioner made the balance payment. Page 68. 17/7/21, which was duly accepted by the jurisdictional divisional forest officer. Page 69 are the, my lord, 70.
What is page 69?
69 is the term deposit, my lord. That was in the form of term deposit. It was, my lord, something like equitable mortgage. It was given.
So you have given, instead of the amount, you have given the term.
Yes,
deposit.
on that there is no dispute, my lord.
Okay.
Yes. Then what had happened, my lord, at page 71, the DFO accepts. With reference to the subject cited above, I have the honor to enclose herein the Google map along with relevant document for preparation of mining plan in favor of Ajit Kumar Nath, LY holder of number so and so. In this connection, I would like to request you kindly to direct the concerned authority for preparation of the mining plan as per Assam Mineral Concession Rule 2013 for a period of 7 years. So DFO is writing to the Director of Geology and Mining. So these are all requirements, my lord. Then, my lord, will kindly come to page 72. DFO is again writing to the, my lord, the petitioner. With reference to the subject cited above, it is to inform you that this office has issued a letter under reference dated so and so. Mining plan not yet submitted from the concerned authority. Hence, you are requested to pursue the matter with concerned authority and submit the mining plan within 7 days. So mining plan will be prepared by competent authority, my lord. So I was asked to coordinate with them and to get it done. Then, my lord, the next page, DFO writes to the Chairman State Level Impact Assessment Authority. With reference to the above, I have the honor to enclose here with mining plan in respect of so and so under Borpeta Road Range for issue of environmental clearance. In this regard, it is to inform you, your good self, that mining plan was prepared by RQP Dr. Abhijit Bora, PhD, and approved by Director of Geologic and Mining. Therefore, I request you to your good self to consider the proposal for issue of necessary environment clearance for quantity of so and so. Now, at page 74, my lord, DFO again writes to the petitioner to get the environment clearance.
Yes, then.
Then page 75, my lord, the petitioner is writing to the DFO. With reference to the above cited above, I have the honor to inform you that I have applied for environment clearance through online system to the Office of the State Environment Impact Assessment Authority. So I'm submitting here with the acknowledgement slip for online application for so and so. The acknowledgement, my lord. Then the petitioner wrote to the chairman also at page 77. Also deposited the necessary fee, my lord, of 1 lakh rupees.
Did you get the mining plan?
Yes. Yes,
Where is it?
page 78.
Page 78 is the amount deposited,
First secretary,
but have you got the mining plan?
no. Yes, subsequently got it.
So mining plans are all stalled because there's a matter pending in NGT. There has to be district survey report. Maximum is district of Assam doesn't have mining. So we are submitting that in NGT, then only mining plan will be cleared.
Okay. Now, my lord, while the matter was at that stage, at page 82, the impugn order was passed.
On the basis of 80.
Yes. Page 82, annexure 19 on 9/11/22. When
your
we express the honor
Your
report.
specific case, the Chaudhary is very simple. That this, you having received the amount, now how can you raise the issue that I did not deposit?
Yes.
Maybe I have done late,
Yeah,
but you have
refused to
condoned
accept
it.
Then also things would have been different. Well, I've got a Supreme Court judgment on that point of waiver mine. It's a case where they have relinquished not to enforce a particular provision. That's it. That is their stand. Now, my lord will page 82, my lord, this is the impugn order. With respect to the subject cited, it is to inform you that writ petition was filed before the Honorable Guwahati High Court, WPC so and so, wherein the matter was raised about payment of bid amount as mentioned in Rule 37 of the Assam Minor Mineral Concession pertaining to Bandorkhua MCA and so and so. Meanwhile, the matter was examined in the office of the PCCF, and after scrutiny, undersigned was directed to revoke the provisional letter of intent, which was issued by this office later dated so and so, on account of delayed payment of bid security, that is equal to 15% of the annual bid amount, which has been construed as violation of Rule 37 of the Assam Minor Mineral Concession Rule. Therefore, the provisional LOI issued by this office later dated so and so stands revoked. So, my lord, DFO has conveyed this order of revocation based on instruction of the PCCF on the basis premise that there was a violation of Rule 37 in not depositing the balance 15% within the stipulated period. That is the simple case. And our answer to that is by accepting and by asking me to take the subsequent steps, you have waived your right. Can I place that one small paragraph of a judgment?
But what right do you have as regards this provisional letter of intent? What is the right of a provisional letter
Well,
of intent?
provisional is a melody. It's something like it's a work order subject to observance of certain formalities. The final work order will be issued. That is, my lord, I have to deposit that balance 15%. I have to submit that mining plan. I have to submit that later of that, therefore, that makes the position clear, my lord. If your lordship would kindly come to letter dated 71. Page 71. First para. In this connection, I would like to request you kindly to. Oh, yes, I'm sorry. First paragraph. With reference to the subject cited above, I have the honor to enclose herewith Google map along with relevant documents for preparation of mining plan in favor of Ajit Kumar Nath, LOI holder. In this connection, I request you. I'm sorry, there's one more letter. What is it? Take any bostu kini dibo lagi. Basically, my lord, after the provisional thing, I'll make the payment of balance 50% and I will get the mining plan approved from.
But I don't understand where is the question of 15% to be paid.
Yes, my lord, it is there. And under rules, it is there.
Let's see.
Yes.
Rule 37.
33 or
37.
37.
Scope of the hammer 10%.
Yes, my lord.
Yeah.
Rule 37.
Which one?
Please come to rule 37. my lord.
Yeah.
No bid shall be regarded as successful unless accepted by the officer competent to accept bid tender in accordance with the provisions of so and so. The highest bidder shall be required to deposit an amount equal to 25% of the annual so and so as security along with additional amount equal to 1.
No, this is the amount which is required. That is why I'm asking. What is 15% is kindly come to
Because I
37,
paid
3 and
10% initially.
Huh?
I paid 10% while submitting the bid. That's why I was asked to deposit the balance 15%. And there is no dispute on that.
So you deposited.
Kindly see 3I. On completion of the bid process, the fall of hammer or opening of the seal bid as the case may be, the highest bidder shall deposit an amount equal to 10% of the bid amount as initial bid security before expiry of the period allowed. This 10% was paid, my lord. Then my lord will kindly come to Roman 3, next page. Letter of intent holder shall deposit the balance amount of bid security that is equal to 15% of the amount of bid before expiry of the period end. So this is the one.
But this won't come into play.
My lord,
37(3) Rule 3 would not come into play because you don't have a letter of intent.
provisional letter of intent is there.
But that is why I'm saying, what is the value of a provisional letter of intent as per the rules?
So that is the procedure they're following. Basically, they should have described it as letter of intent.
No, because we categorically say in that letter that we will issue the letter of intent after you get the mining plan.
Yes.
Can we see?
Yes, yes.
The final letter of intent will be issued considered after fulfilling the above conditions
Yes,
as laid down in the
yes.
memorandum.
Yes.
So they have not issued the letter of intent.
Final letter of intent they have not issued.
So where is the concept of a provisional letter of intent?
That's the procedure they are following, my lord.
And if there is a provisional letter of intent is the question, what rights does it flow to you?
No, my lord, it's not the case of the department that this provisional letter of, supposing post provisional letter of intent, if I would have deposited the 15% within time, then it would have been okay. Because the final order says, only ground on which it has been revoked is, I did not deposit the 15% within time. And my case is, my lord, by accepting it, you have waived your right to take that step. That is my simple case. And I'm relying on that Supreme Court judgment, my lord, 2011-14 SCC 770.
Yes.
Para 41. Para 41 at page 793. Waiver is an intentional relinquishment of a right. It involves conscious abandonment of an existing legal right, advantage, benefit, claim, or a privilege, which except for such waiver, a party could have enjoyed. In the fact, it is an agreement not to assert a right. Now, by accepting that belated 15% payment, my lord, now they can't, take the plea now that we have not paid within time. Therefore, in terms of Rule 30, there is a violation of Rule 37.
But where is the concept of a provisional letter of intent?
In Forest Department, there are a few checks and balances. The person, when he gets a provisional letter, he has to submit a mining plan. If he fails to get that mining plan, consequences follow. That is the reason, issue, that is the reason behind we use the word term as provisional plan. Because he has to fulfill certain other criteria also. Mining plan is a must. He has to
But
come.
does the rules stipulate provisional mining letter of intent?
No, it says provisional letter of intent.
Does it say so?
No, rule doesn't say so.
Rule doesn't say so. But the issue at Forest Department is that since mining is subject to certain other geographic issues, so he has to come with a mining plan, he has to deposit the money. When you are satisfied, then he gets the final letter to commence mining.
Does the rule say that for a letter of intent, you require the mining plan? Where? Mining lease is different. That you require a mining plan. But can you say that for a letter of intent, you require a mining plan? Because without a mining lease, you cannot go ahead with a mining, mining.
My lord, chapter 9, rule 48.
Chapter 9,
48, my lord.
chapter 9, which page?
My lord, page, kind of similar, page, rule 48 of the rules,
Rule 48.
48. Any mining operation.
Under mineral concession, under the rules against by the Indian. Yes, there's no quarrel with that.
Yes.
But the question is whether it is required for a letter of intent. For issuance of a letter of intent, do you require a mining plan?
Final letter of intent will be required.
Where? Mr. Chaudhary, I've become more enlightened nowadays with these minds after you left that case, na? Mr. Saikia is arguing the matter. It's become more and
Well, excuse me for some time, I was not into that, this area, I was not there. I was on the total.
you are the forest
No,
department.
but I was totally different footing. Well, my senior counselors, one of seniors argued that there is estoppel. But I was going to answer that they cannot be estoppel waiver against law, man. I have also judgment. This is the law. Law says like,
Now, Lordship,
This-
kindly come to page
that was the
62,
issue.
my lord, that is the letter. Page
I'll
62.
I need some time to find out.
62 that helps. Page 62, my lord.
Yes, I've read it many
The
times.
mining contract area falls under so and so, so and so, so and so. And you are hereby requested to submit documents like mining plan, environment clearance, etc. And get it approved within 45 days from the date of issue of this letter. Final letter of intent will be considered after fulfilling the above condition as laid down in the memorandum issued by the ministry. Perhaps, my lord, this is a requirement envisaged by that Government of India Ministry's letter.
No, because for letter of intent, you don't require a mining lease, mining plan. For mining lease, you require. a mining-
I think, my lord, they are insisting on because of that Government of India letter, Minister of Environment Forest. The last line of page 62, my lord. The final letter of intent will be considered after fulfilling the above condition as laid down in the memorandum issued by the Minister of Government. Let them place this letter, my lord, that will clarify.
No, I'll reply to that issue, my lord, first, my lord, that there cannot be any estoppel. And my lord, we have divided, these rules have divided three kinds of concession, my lord. One is permit, one is contract, one is lease. So, my lord, the definition at 49, it specifically says any mining operation.
My lord, on one occasion, an argument was advanced on behalf of the Forest Department that because it was done by the DFO, he is not competent.
I remember, this matter came up before me.
And my lord, kindly have this. This power has already been delegated, my lord. Kindly have it. The power stands delegated, my lord. This is by the government, my lord. And this similar in exercise of the power conferred under Rule 21E and Rule 3B, and for smooth functioning of the field level activities, divisional forest officers of the concerned divisions are hereby declared to be the competent authority to execute various provisions of the Assam minor mineral concession rule in respect of Schedule Y. They will, however, obtain approval from the respective senior officer as per delegation of financial power as and when required.
Let me see, come to page 38 of your report.
Read petition. Yes.
There is no concept of a provisional finding a letter of intent.
The preferred bidder shall be considered to be the successful bidder upon continuing to be in compliance with all terms
No,
and
no, no,
conditions.
no. Prior to that declaration, number 37, last. Declaration of successful bidder and grant of mining lease
Yes,
permit contract.
yes.
Then you
The
see,
lease shall be granted to bidder in the following manner. No bid shall be regarded unless accepted by the officer competent to accept the bid tender. The successful will be required to deposit an amount equal to 25% of the annual dead rent as security along with additional amount equal to 1. Process for completion of various stages of payment as specified under sub-rule shall be as follows. On completion of the auction, as the case may be, the preferred bidder will deposit so and so and so. No, Lordship is correct. That way,
amount deposited towards initial will be adjusted as the bid security on acceptance of the bid by Iman, and a letter AR will be issued here. Kindly see therefore. So the concept of a provisional letter of intent is not there.
concept of letter
Perhaps,
of intent
Madam,
is there.
Why will a person get a provisional and then go for a mining plan? Mining plans are expensive. So therefore you have to issue a letter, then he will go, then you may cancel the letter of intent if he doesn't produce within a period. It is also mentioned here, if he doesn't produce. And within that period, you have to start with it. So therefore the concept of provisional, now if there is no provisional letter of intent, no letter of intent, what is the rights of the petitioner?
Lordship is correct. There is no
I
final
am not correct, but I am asking you. What is the right of a
Perhaps this is
petitioner?
the nomenclature they have been following all together. But provisional, I also don't find any rule which says that there's a.
Forget about your rules. Your tender doesn't say. What is your tender notice? Your tender notice does not conceptualize this, the provisional letter of intent.
Have been only a letter of intent.
It could have been a letter
Upon
of
the
intent.
upon deposit of 10%.
So once the 10% is deposited, you issue a letter of intent. And thereupon you ask them to get a mining lease and mining plan, and from there you can see, fails to deposit the 15% towards so and so, and also fails to execute the agreement after issuance of the demand, the same shall be deemed to have been revoked and a 10% amount of the AR shall be forfeited. In addition, the letter of intent, defaulter shall be liable to deposit unpaid amount of rupees AR to make 25% of the year. Fails to deposit the unpaid so and so on the demand and shall be recovered under so and so. Now, if the question herein is the person concerned have not yet deposited, the letter of intent has not been issued, then under such circumstances, is it necessary for him to pay that 15%?
This is a bit different. They paid, my lord, beyond the period allowed.
Understood,
which we found
but
out.
that is dependent on a letter of intent being issued. If you don't issue the letter of intent, where is the question of him paying 15%? Forget about his waiver acceptance.
Let us delete the word provisional. That goes.
No, this is a very relevant thing. There is no concept of you bring in another stage somewhere from somewhere.
Well, we are very concerned about.
Mr. Chaudhary, if you are getting my point.
Absolutely.
No, the question of getting a provisional is
If
not
there
there.
is no letter of intent, then there is no obligation on my part to make the balance 15%. That is what Lordship would like to
Yeah.
say.
50% will only be the right thing.
Well, that is not the pleaded case, my lord. It is
Forget about his pleaded case. We are considering, we are 226.
well, I am on a different footing, my lord. I am on a different. I'd like to reply back, my lord. The rule 37 may fail, my lord.
No, my lord,
37
to be
Thus, Rule 37 conceptualizes payment of the provisional means the provisional letter of intent. No,
37 does not speak of provisional letter of intent. It
there's
speaks of
nothing
letter
out
of
there.
intent.
Just
37
drawing
C,
your attention somewhere.
37(3).
Unless here the timeline is very important. When he got that letter of intent, we deleted word provisional ballot. 40, when
You have not issued
Kindly
the
see,
letter of
the
intent.
letter of intent holder shall deposit the balance
Yeah.
amount of the security.
That is why I'm saying-
37(3). It is the letter of intent holder who will deposit the balance 15%.
Yeah, the letter of intent shall deposit the balance figure of the year. So if he is not a letter of
Next
intent
rule makes
holder,
it
where
more
is the
clear,
question?
Lord. 3, Roman sub
That
rule
is what
clause
I'm
3.
saying.
Letter of intent holder.
Yes, that is what I'm saying. If you have not issued the letter of intent, why is his liability to pay this 15%?
well, page 67 per month
Of
the petition. This has come up now, madam. Otherwise, there
which
also
I am
was-
reading it.
No, that's correct. I am not denying that. We also
the only
proceeded on
one
that
that we
basis.
paid it lately, we accepted it, so we waive our right and final letter of intent, whatever, madam.
So now you accept, you waive your right.
Well, they cannot be, I'm not waiving, madam. I have a judgment, madam.
I'm not on that. You have to apply the law. That there is a statute. For that, if there is a statute says something to be done in a
It's a
particular
statute
manner, the
contract.
question of waiver does not arise.
Yes.
Fantastic.
Yes.
Then you have to apply the statute when you are issuing a letter of intent. Without the letter of intent being issued, can you ask him that you deposit the 15%? Tell me. Give me a good reason for that.
Then lordship has to grant me some time. I have to, this has come up new. Because otherwise I was, like, lordship is very correct.
Oh, you, the senior counsel has made the argument. It is on in the question of law. It's a question of law.
Here counsel has made the argument. That is the reason I'm asking for, I'm entitled to also, madam, some time, madam.
What is there? Because
Otherwise,
if you want to apply the statute only for this A, but not for the sign, the B which is there, then how does it apply? Either you have to accept that, yes, I have waived my right, or you have to say that way. Then in that case, the waiver would not apply. The Supreme Court judgment will apply.
then Supreme Court also says, madam, there cannot be waiver against any estoppel or waiver against law. Law says,
Absolutely,
Yes.
but the waiver will not apply provided you have issued the letter of intent.
I need some time to answer that.
Tomorrow, you need to finish it off.
My lord has fixed.
Something has to go.
No, my lord has
Because
fixed that.
there's a state.
No, my lord has fixed another matter 21 or that Wednesday also. So I have to go through that matter also.
This is a small point involved.
My lord, giving
You
provisions
want
are
to
there.
be a party? Let him be a party. I brought you I brought the issue out there and just put it somewhere by way of an affidavit.
Lots is absolutely correct. Did not strike.
Huh?
To be honest, my lord.
So you just bring it by way of a short affidavit.
Remember, this was the time when country was passing to an unprecedented phase, where even with the limitation also was not running by virtue of the court's order.
My lord, the law regarding the minerals is very harsh, but there is Supreme Court judgment, even if rules don't provide for any kind of extension.
No,
In
on
our
the
court
earlier
also held, madam.
occasion, the argument of
Our
the
court
forest
also
department
held
was
that, madam, there
regarding
cannot be an
DFO's
extension.
power. Now, if you know.
But Mr. Chaudhary, you just bring a small affidavit, additional.
Fine.
Mr. So-and-so, this is an application file, I economic, 2745 of 2000. This is an application filed by the applicant. Seeking liberty to be arrayed in the accompanying writ petition being WPC number 7635 of 2022. The ground on which the applicant seeks including the accompanying writ petition is that the applicant is an interested party to the to the notice inviting tender which have been issued pursuant to the cancellation of the settlement in favor of the writ petitioner. And by way of an interlocutory, by way of an order, by an order dated so and so passed in IA number so and so, this court had stayed the further proceedings pursuant to the said notice inviting tender dated so and so. So taking into account the above, this court is of the opinion that the applicant is required to be made a party. Accordingly, the applicant herein is included as the respondent number 7 to the accompanying writ petition. The applicant submits that he would like to file an a 7 ISL report followed by 90 that is memo of parties they will file within 2 days. You file your memo of parties. ISL report. Mr. As Botaku, the learned counsel appearing on behalf of the newly impleaded respondent number 7 submits that he would like to file an affidavit in the matter. Full stop. Mr. Ken Chaudhary, the learned senior counsel also submits that they would like, that the petitioner would also like to file an additional affidavit. So, taking into account the above, list this matter again on 27th of November 2024. Interim order passed earlier shall continue till the next date. What about the Paresh Kumar Roy? That person died.
Because we have filed an application for substitution that has been allowed.
Can-
Let it come on
I objected
27.
to it, my lords. I objected to it because these settlements are personal. It was
No,
not a
no,
family
no.
concern, neither
No,
a
no,
company,
the
my lords.
question is, the 25% which I have deposited, that is liable to be forfeited.
It's forfeited.
No, no, no.
Otherwise they will forfeit it.
No, not forfeited. My lord, that I will
No,
take
if they
instruction.
don't forfeit, my
I'll
lord,
take
they have got
instruction to
nothing
the
to say.
effect. We are not forfeiting that because it died with, it expired with it. With liability, it's a personal contract money goes with it.
But what about the money? Is he
I'll
going to
take
give
instruction,
it?
next.
Ah, yeah,
He
let it-
can't be petition of liquidity. Mr. D. Gogoi, the learned counsel submit that the writ petitioner in the instant proceeding had expired. First off, Mr. Ken Chaudhary, the learned senior counsel submitted that pursuant thereto, the
Legally.
the legal representatives of the petitioner have already been substituted. This court had put a specific query upon the learned counsel appearing on behalf of the party as to whether the cause of action further survives pursuant to the death of the original petitioner, taking into account that these are personal settlements. Mr. K. Chaudhary, the learned senior counsel submitted that the amount of the 25% of the bid amount have been already deposited by the original petitioner. And as such, the question of forfeiture of the said amount to derive if the repetition is not allowed to, repetition is not allowed to continue. On the PowerPoint from Mr. D. Gogoi, the learned counsel appearing on behalf of the Forest Department submits that he would take instructions as to whether the respondent authorities would take any steps for forfeiture of the said amount. This is the matter again, same date.
Admission item 7.
PWD. Yes, why you are not doing it? No.
But I need some time about the PWD is not a party. In the repetition,
It is not there, but the fact that PWD is not required to be made a party. But the assessment is to be made by the PWD there, pursuant to the award being passed. You have to do it, then only the competent authority can do something.
in absence of the instruction, in absence of the instruction, I have to obtain the instruction.
The pursuant to the order passed by this court on 3/10/2024, Mr. N. Gusami, appearing on behalf of the district administration, had placed before this court an instruction to the effect that pursuant to that, in compliance to the order dated award dated 19/4/2014 in RR case number 23/2012, the concerned departments have been asked to submit a reassessment value of the buildings of the Zirat as on the date of taking over the possession by the NHAI. Full stop. However, it is also seen that the last of such communication was issued on 16/2/2019. It has also been mentioned in the instruction dated 5/11/2024 that no reply has been received from the concerned department regarding reassessment. Full stop. This court inquired with Mr. N. Gusami as to who would be the department who would be making the reassessment on the basis of the order being passed by the award being passed by the arbitrator. He submitted that the same would be the PWD department. Full stop. During the course of the proceedings, while the matter was being taken up, Mr. Dean, this court, full stop. Under such circumstances, this court is of the opinion that the PWD department opinion that to give due to give effective orders in the instant petition, the PWD department of the government of Assam is required to be made a party to the instant proceedings. Accordingly, this court impledes the commissioner and secretary to the government of Assam, PWD department having his office at Dispur, Guwahati 781006 as the respondent number 6 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court during by tomorrow. While the matter is being taken up, Mr. Dina, the learned standing counsel of the PWD, was present and he duly accepts notice on behalf of the newly included respondent number 6. Taking into account the above, Mr. N. Gusami have also during the course of the hearing provided the details have provided the instructions as well as the other documents accompanying thereto to Mr. Dinath for taking appropriate instructions. List this matter again on 27/11/2024. This court directs the PWD department as well as the department along with to consult the NH division and to consult the authorities from the National Highway Authority of India and make the assessment in terms with the award dated 19/3/2014 passed in case number RR 23/2012 and placed the same before this court on the next date. The instructions so placed is kept on record and marked with the letter X.
Lordship, can you say Commissioner and Special Secretary, PWD building?
Huh?
Commissioner and Special Secretary, PWD building. Access.
PWD building.
Item 8.
Right. The consultation of National Highway, because what happens as well as the National Highway and the competent authority. Otherwise, what will happen? The National Highway will come next day. So we are not going to pay now, taking into account they didn't do it enough without consulting. There are 5-6 cases.
Item 8.
Yes, Mr. Viswas.
May I pay that to Peru, the earlier order passed by the law?
Yes. You have taken the land.
This was, wait, sir.
What is the name of the petitioner?
Alimuddin Malik.
Alimuddin and only one or two petitioners?
Yes, sir.
Alekuddin.
Kalakuddin. Their brother, Malik.
So as per the instruction, there is no acquisition.
But the affidavit filed by the secretary kindly. There is another affidavit filed by the secretary of the panchayat.
That will do many things. Where is that?
My friend is appearing for them.
Secretary and President, effectively of Pochim Puruketi Gaon Panchayat. What does he say?
Six kindly, while there are 6 page 46.
What did he say?
In paragraph 3 of the petition, the deponent respondent 5 begs to state that the Panchayat authority never forcefully occupied land, not occupied land of the petitioners measuring 3 bighas at any point of time. The said repairing work of by filling artwork carried out under the scheme, namely construction of agri pan from Askan house to the Bella Palla PWD road under MGNR 1415. Initially, the other landowners of the surrounded public was allowed to cut art from their respective plots of land, considering the development work of the location. According to the engaged workers under job card, holders started art filling work of cutting art under the guidance of spot supervision of the concerned BRS and site engineer without causing damage over the agricultural land of such land owners, particularly over the land of the petitioners in question. On the other hand, no standing crops were damaged due to the repairing work in respect of the state public road. Further, deponent respect number 5 to deny the allegations of threatening the concern. That is a different thing, right?
Why you are looking into the chita? When we ask the circle officer to do so, he is on the field. So you have to get a long report as regards this land, whether in that land concern, whether there is anything. Why is he only mentioning about the chita? On the books, it may not be there. But the question is on land, on field verification, whether there is any acquisition of that land of the petitioner. That is the question.
They have not produced the field verification report also, madam.
No, they have not done.
Yes, not
You
done.
see, what they have done is it's a very clever way of saying. As per land records available in this office, there is no record note in the Chita. We are not concerned with the Chita. We are concerned with the field verification. What is that? Isn't this report and this report contrary? We ask the circle officer for giving such type of reports, asking to be present. This is not how it will be. And why we should not initiate contempt proceedings for not submitting this report by you. Against you. Contempt proceedings against you. This is, you are trying to mislead this court. Absolutely. Why did you give me this report? Read this report. Read this report. What does it say? What does it say?
Getting any acquisition of particular part of like that.
As per Chita. Okay. The same circle of this is by the additional district commission. Read it. Doesn't they say that at bag number 144, there is a road in the report of the additional district commissioner? If this is the report which has been submitted by the additional district commissioner, then why on earth did the circle officer make such a careless report before this court? Do they think you can submit reports like this?
Nothing can till last order. Last order.
Accordingly, this court directs the circle officer, Hothebari Revenue Circle, to submit a report before this court as to whether any part of the land belonging to the petitioners have been acquired or taken over by the respondent authorities, more particularly the respondent number 2 for construction of any road. That this court have perused the report so submitted by the instructions so submitted by Mr. N. Gusami, the learned counsel, appearing on behalf, government advocate, appearing on behalf of the district administration. While hearing the matter, this court have been placed two conflicting reports. One by the additional district commissioner dated 21/6/2024, isn't it? And the other by the circle officer dated 4/10/2024. Taking into account the above, this court directs the district commissioner, what is his name, of which place? Corbetta, to submit a report, file an affidavit explaining the contradictory natures of the reports being submitted by the revenue authorities under his jurisdiction, as well as also state in clear terms as to whether upon field verification, any land of the petitioner have been encroached upon for making a construction of any road. List this matter again on 18th of November. 20th of November 2024. The affidavit be filed without fail by 19th of November.
Hey, bro.
Item 9 to 11.
None appeared on behalf of the petitioner on call. None appeared on behalf of the petitioner as well as for the fishery department on call. The instant petition was filed. Seeking appropriate directions upon the superintendent of police in Sukia to take immediate action to stop all fishing activities in Dibru, Part 1, Meen Mohal. Taking into account that the period for which the petitioner was allowed is over, was granted the settlement is over. Nothing further survives in the instant repetition. Accordingly, the repetition stands dismissed as infructuous. The present contempt applications have been filed with honor today, alleging violation to the directions passed by this court dated 6/12/2022 to 2017. Passed in WPC number 4902/2017. It is seen from the affidavits so filed by the respondents that the orders so passed were complied with. And as such, the question of a willful or deliberate violation to the orders passed by this court do not arise. Accordingly, both the contempt proceedings stands dropped.
Item 12.
Can it be taken after some time, some instructions are on the way, madam?
What?
Some instructions, madam, are on way.
Well,
The
department
departmentals, I have a
is doing
status
all this.
report. Madam, habitat of the petitioners, madam, they are mostly majority of them out of the map now. Because there were two maps, one prepared by Assam Forest and Survey of India, madam. So we have, the State Wildlife Board has decided to accept the map prepared by the Survey of India, madam. And wherein, madam, the habitat of the petitioners are left out. And it is and there has to be a rationalization exercise.
So, Mr. Chaudhary, what do you want here?
Our case was, my lord, when was a non-cadastral case. Without any notice under the relevant section 26, my lord, our area was included within the wildlife site. Because, my lord, there is a procedure, they'll have to notify, they'll have to call for objections. And my lord, initially, it was not a wildlife sanctuary. Initially, when, my lord, our area was included, subsequently, straight
Without,
notice. That is our only case.
Madam, something has come now, I just mean because.
but why the state government is not filing affidavit?
Because it was tagged along with the PIL, madam, it's over to PIL, it was that's very, just very recently, madam, so we'll file affidavit.
Very recently is 1 year, 4 months. The very recent.
What instructions come, madam, wherein it is that the village of the petitioner should be excluded. That is the issue, madam.
If that is done, we know, we can, if there's that.
Then file an affidavit to the effect.
In fact, madam, in that PIL, madam, there is a committee constituted by the chief secretary, under the chief secretary, which will look into these grievances. Those grievances have been put forth now and is pending consideration. There is a proposal to oust this village. Okay. And also not this village because, madam, in the original map of Assam Forest, many habitations fall. To reduce those conflict and also minimize the pressure on wildlife, madam, we have decided to go for the state map prepared by the central agency.
Anyway, if they file an affidavit, then we will
I will file a bit, madam, like, I need.
Mr. Peter Boy, the learned counsel appearing on behalf of the forest department submits that pursuant to the decision of the committee so constituted by the division bench, learned division bench of this court, a decision has been taken in respect to the petitioner's village. He would like to bring on record the same decision by filing an affidavit. This matter again on 20/11/2024.
20, I'll not be there. Can it be on
Not
27?
necessary. If he comes up with that affidavit to that effect.
Item 14.
Yes, what is this?
I have nothing to argue this matter, my lord, already filed is over, my lord. There is a interim order. There is a 9/7/18 until further order by the passed by the honorable court, my lord. Government has not taken a, they have not filed an affidavit. I have also don't know what is the present position of the status.
Well, there's a state to a notice inviting tender.
Yes, my lord, for 1819, my lord.
My goodness.
And petitioner's prayer was to continue, my lord, not to allow for going for tendering, but to allow him to continue, my lord. So it's 1819, my lord, already.
Nothing remains.
Nothing.
What right do you have? How are you challenging this?
So
Your agreement was for how long?
He wanted for another
another 1 year.
So 1 year has, when his prayer is allowed, then also 1 year. also.
Yes, mister, what is your case?
My case is, my lord, I was selected for, I have had tender was issued, I have the part of the sentence, I was selected, the petitioner was selected for 1 year. There also the deposit the security money, but department allow me only for 1 month getting the goods money. And they have published another tender. Then I have come to the court.
You got a
Honorable
stay.
court passed the interim order and the.
Then? You got a stay. And you were then performing. For 1 year, did you complete?
Therefore, completely.
The learned counsel appearing on behalf of the petitioner submits that the instant repetition has now become infructuous, taking into account that the period for which the tender was floated and thereof, and which was stayed by this court is long over. Taking into account the above, the instant repetition stands closed as infructuous. The interim order so passed earlier stands vacated.
Nine to 10, though my names are shown, I am not appearing in those cases. 9 to 10.
I put none appears. Yes, Mr. Roy.
My lord, last question, lordship, indicated,
Oh, it's a bad case of yours.
Lord,
You take
that
the-
is why I've got sufficient indications for the lordship. That is why, my lord, before you, my lord.
That day I allowed you to deposit the court fee.
Lordship, I did it.
That I've seen it.
My lord, I have obtained written instruction from my client, my lord. My client has instructed me to make a prayer before lordship to my lord, allow them to give liberty, grant them liberty to approve the government. Because earlier also they approved the government and government reduced it. Government has the
Then
power.
again you come here.
No, that is different, my lord. The only liberty to, because it is the.
But the
government
fact
on-
that the rate by which they have increased was right.
No, my lord, that's right, but my lord, they have increased 3 times. Now, in the other case where the municipality had, because these are the vetos, my lord, which you have
But that
opted.
was your cases were not increased. If I remember correctly, the matter.
My lord, my case,
All the other people, they were increased. But in your case, there was not an increase for a long period of time.
that's right, that's right. We only said, my lord, that it is 3 times and in their case, it's 2 times. No, my lord, my lord, since in our case, we had another pair also. Because since it was a, my lord, the visas were auctioned to us, we paid very little consideration on that. My lord, I'll place before lordship the written instruction because lordship may kindly consider this because.
Mr. P.K. Roy, the Limit Senior Counsel, assisted by so-and-so, submits that his assisting counsel have been instructed by the petitioner, by the petitioner association that they would not like to further pursue the instant petition. Rather, they would take their file appropriate representations before the respective authorities. And as such, the petitioners would not like to further proceed in the instant matter. Taking into account the above, the instant petition stands closed on the blood. Liberty, however, is given to the petitioners to approach the concerned respondent authorities are agreed with their action.
Item 16.
Yes.
Well, before I start, I may just indicate that on previous occasions, number of times it has been adjourned at the instance of the respondents for their requirement of placing the records. I understand that today the records are
Record received.
So, my lord, I start with the facts first. The matter relates to imposition of a penalty on the writ petitioner in a pursuant to a disciplinary inquiry, which the respondent bank had initiated on charges of granting overdrawal benefits in respect of 5 accounts. And out of the 5 accounts, my lord, 1 account was of the petitioner himself. That was one limb of the charge. The other limb of the charge was that there was an occasion of overstaying the leave. That is leave without, leave without authorization. But that leave without authorization aspect was regularized in a sense that he was granted extraordinary leave, and extraordinary leave was granted without giving him any salary. So in a way that was regularized. So only thing remaining was with regard to his act of allowing 5 overdraft facilities in respect of 5 accounts. And out of which 1 account belonged to himself. It was his overdraft account. Now in the written statement that was filed in the disciplinary inquiry, he admitted it to the extent that as far as his account was concerned, that overdraft was done, overdraft was allowed, but the bank recovered the money from him with penal interest, which constitutes one of the penalty under the service clause.
Yes, Mr. J.K. Goswami. Court directs you to dispose of the appeal. You dispose it with one liner. So one apex court, apex bank appeal comes to be then think that it is not an alternative remedy. Is this the manner in which you pass the order? Page 56. You are an appellate authority. But your only question on his appeal was not on the only on the punishment. His appeal must have been on the entire aspect. What is this type of orders being passed? Huh? You can file an appeal in this manner. What new materials will come into light? You must have challenged the appeal on merits.
Yes.
What new materials? You have to reconsider as to whether, because you see, the sports jurisdiction is limited. This court can't go into various factual aspects. Therefore, the question is of an appeal. Now, this appeal have not first, he files an appeal in 2018, or 16 or 18, you do not dispose it of. Now you dispose it of in one liner. And the matter has been pending from 2021. Set aside this. Go and properly appreciate everything, give him a hearing and pass an order. You can't do this in this manner. When it is an appeal, you are to apply your mind as an appellate authority, not you place it before the ear and they are going to confirm and no, we don't like it.
But one aspect I will submit before your lordship, the man has attained the age of superannuation now. That is,
Same thing.
so they will have to also take into account the fact that the appeal has to be decided not only on merit of it, but also the fact that the future prospect of him being given any service benefits, that also will have to be gone in. In case the appellate authority decides of
No, if the appellate authority overturns the decision, or for that matter, the appellate authority will have to give all consequential benefits.
all consequences.
That is there, that is the law. But the fact that the appeal has been decided in such a callous manner. You are the standing counsel. Then we are not explaining to your clients properly.
At that time, I was.
Oh. They missed out the chance of Mr. Goswami being there. To dispose it of, directing them within 3 months, you finish it off by giving an opportunity of hearing. Heard Mr. S. Dr. the Senior Counsel assisted by Sunil hearing on behalf of the petitioner, Mr. J.K. Goswami, the learned counsel, standing counsel, appears on behalf, and the Mr. J.K. Goswami appears on behalf of who is the standing counsel of the respondents, appears on behalf of them. The instant writ petition has been filed challenging the inquiry report dated 2011-2012, submitted by the inquiry officer. Semicolon. The order passed by the managing director dated 29/7/2013, whereby the petitioner was dismissed from service, as well as the rejection of the appeal filed by the petitioner as communicated by letter dated 27/2/2020. Is there any records out there, anything more? Nothing. In fact, this matter came up earlier before me, no? Once. That is why. Remember now.
They wanted to substantiate their stand through records. That's why I said it is.
No, there's nothing on record. Do you have anything? any other order? Because this seems to be only a communication. Have a look at that. Did you give the petitioner an opportunity of hearing? Give it to me. I'll be fast in looking at it.
The personal hearing was given way back in the year 2013, prior to passing of the judgment of this honorable court, not thereafter.
Whether that those people are there. Then hearing given to A and pass order by Z. Yes. This only happens in property banks.
Page 79 for evidence. Page 79. Annexure.
Where is the board's resolution?
That is at page 79 of the writ proceeding.
No, that is your decision being conveyed.
No, but they have enclosed the resolution at page 79 of their affidavit.
In my affidavit.
Their affidavit, Lordship will find page 79. We have given an extract.
What was his age at the time of dismissal?
2012. Will be around 48 years.
Was there any criminal proceedings initiated against him?
No.
The agenda 5 and resolution.
Yes.
That is what?
That is-
Board's meeting held on 28/8/2018.
And that was communicated to me in the year 2020, and that too pursuant to the order of the Honorable Court.
Now, this is in the agenda. You say the chairman instructed the managing director to prepare a speaking order, if any, as per the suggestion of the additional Advocate General Assam,
And submit. to the
and
same.
submit the same to the High Court.
Yes.
The board adopted.
The resolution.
And
It
this,
is pass a speaking order.
no. This is they had communicated, which your Lordship has seen at page 56.
Huh?
So the writ petition is communication of this one.
We are more busy in taking opinions. We are communicating, this is a 24/1/2019. There is no speaking order, no speaking order. Okay, this is one thing. Let's see the appellate provision. Where is that?
Provision of appeal is in rule 47.
Let's see the appeal. Where is the memo of appeal?
It submitted a representation that is at page 45.
Got it. You filed the appeal on 12/8/2013.
15/3/2013.
15.
3/2013, page 45.
There is another appeal on 12/8/2013.
12/8/2013, whether that is
There is an appeal on merits. Very good. Raise the appeal, otherwise, in your petition.
in your repetition, that is at page 45.
Okay, so lordship, it is as per 48, rule 48. Against the order passed by the managing director, it is the board.
As per the service
No,
rule,
there is another one appeal which is there. That is what I said, 12/8/2013. You get it? There's an appeal on 12/8/2013. That is actually the appeal. Otherwise, this appeal is to the
managing director.
the petitioner also doesn't know. Leho. I'm challenging who. The case of the petitioner herein that a show cause notice dated 30/10/2010 was served upon him to show cause as to why disciplinary action should not be initiated against him under staff rule 37 and 38. For his unauthorized absence from duty for a period of 85 days from 14/7/2010 to 29/8/9/2010, amounting to misconduct, gross irregularities, gross negligence of duties. To the said show cause notice, the petitioner submitted his defense and stated that he had not violated the staff rules 37 and 38 as alleged. Subsequent thereto, the petitioner was served with another show cause notice dated 7/5/2012, whereby the petitioner was asked to show cause as to why penalties prescribed under section rule 46 small a of the staff rules should not be inflicted upon him for committing gross financial irregularities, breach of trust, violation of the bank's rules and procedure, misuse of official position, and acting in a manner detrimental to the interest of the bank. The allegations, as mentioned in the said show cause notice, was that the petitioner had allowed overdraft in 5 accounts without obtaining adequate securities and without proper documents. The petitioner was therefore asked to furnish a written reply of defense within 10 days. The petitioner thereupon submitted his written statement of defense on 1/6/2012 against the said show cause notice, denying the various charges. This court would not like for the present to to deal with the specific reply and these charges. Pursuant thereto, the petitioner was issued another show cause notice on 8/6/2012, wherein there was another allegation made under Rule 46B of the staff rules, asking the petitioner to show cause as to why penalties prescribed under Rule 46A should not be inflicted upon him for willful negligence to duties, irregularity of attendance, and unauthorized absence. The petitioner was directed to submit the written statement of defense within 15 days from the date of the communication. The petitioner submitted another written statement on 25/6/2012 to the additional charge framed against him, stating that he was not in sound health when he joined the Diffu branch of the bank. Thereupon, one Sri Dhrubajyoti Gogoi, Zonal Manager, Northern Zone of the bank, and Sri Parthasarathi Mukherjee, Accountant, Tinsukia Branch, were appointed as the inquiry officer and the presenting officer. Subsequent to the inquiry which was made, a report was submitted on 20/11/2012, whereby it was opined that the charges which were leveled against the petitioner were proved. Thereupon, a show cause notice, another show cause notice was issued on 11/2/2013 to the petitioner, asking him to show cause as to why penalty prescribed in the Rule 46 small Roman 6 of the Staff Rules 1980 should not be inflicted upon him by supplying a copy of the inquiry report within 10 days of the receipt of the notice. The petitioner thereupon submitted a reply The petitioner was also given a personal hearing in that regard. Thereupon, the record further reveals that the managing director of the respondent bank passed an order in terms with Rule 46, bracket A, bracket Roman 4, no? Of the Staff Rules 1980, thereby dismiss the services of the petitioner with immediate effect. Further, it was mentioned that the period of absence during his service in the Diffu branch for the period from 14/7/2010 to 6/10/2010 for 85 days would be treated as unauthorized, and accordingly, the petitioner be granted extraordinary leave without pay for this period of absence for these 85 days. It was also mentioned that the amount recoverable from the petitioner on account of pecuniary loss caused to the bank due to his irregular action may be recovered from him as per law.
But, sorry to interrupt, the punishment was under 46A6. 46A6.
A6, Roman 6.
Roman 6.
No, no, the petitioner thereupon filed an appeal on 12/8/2013. Isn't that?
Yes.
12/8/2013. Before the board. Yeah. Before the board of directors of the respondent bank, as per the mandate of Rule
48C. Order passed by the managing director to the board.
48
C, small c.
on C. It was Rule 48C of the Staff Rules 1980. The said appeal, however, was not disposed of for a long time. And under such circumstances, the petitioner was compelled to file a writ petition being WPC number 4416 of 2018. The writ petition was disposed of by the order dated 16/7/2018, whereby, taking into account the limited prayers were made, this court directed the writ petition directed the respondent bank to dispose of the appeal by placing it in the next immediate sitting of the board of directors of the bank. The report revealed that the state matter that the appeal was placed before the respondent board, before the board of directors of the respondent bank on 28/8/2008, wherein it was resolved that as the petitioner had failed to bring any, had failed to wherein that wherein it was resolved that as the petitioner had failed to bring new materials to consider relaxation of his punishment. The appeal was dismissed. This order was intimated to the petitioner on 27/2/2020. By the managing director. According to the instant it's an input for the in the country hearing on behalf of the submitted. Then when the appellate provision is provided, the appellate authority is required to reassess the material from the court as to whether a case has been made out for interference. He submitted that a principle of the impugn resolution would show that the board of directors had treated the appeal as a review and have dismissed it on the ground that no new materials were placed. The very senior counsel further submitted that from the materials and reports, it will be seen that the petitioner has filed the appeal contesting the findings made in the inquiry report on merits, and therefore, it was incumbent upon the appellate authority to decide the appeal on merits and give new reasons. Else, such an order passed by an authority without reason would violate the mandate of Article 14 of the Constitution. Anything else? That some order somewhere. You see that this court had directed on the earlier occasion to Mr. J.P. Vishwami, the learned counsel appearing on behalf of the respondent bank, submitted that the petitioner was rightly dismissed, taking into account the financial irregularity, taking into account that the petitioner herein was found to be involved in financial irregularity. He therefore submitted that when loss of confidence is one of the reasons, the question of that if there is a loss of confidence, the employer has the authority and jurisdiction to dismiss the employee. He therefore submitted that there was no illegality in the order passed by the managing director inflicting the punishment of dismissal upon the petitioner. Which these aspects were duly taken note of by the board of directors of the respondent bank. And accordingly, and on the basis thereof, the resolution was adopted on 28/8/2018, and which was communicated to the petitioner on 27/2020. Anything more? I have heard this court have duly heard the learned counsels appearing on behalf of the parties and have perused the materials and record. This court have also perused the the records which were sought for by this court upon being produced by Mr. J.K. Goswami. The reason why this court, it is very pertinent to take note of that apart from the resolution which was adopted on 28/8/2018 and the communication dated 27/2020, there is no other document which would suggest in any manner, there is no other documents in the records which would suggest in any manner that any reasons were given to the appeal, to the contentions of the appeal for rejecting the appeal by the board of directors. It is a well-settled principle of law that in order that an appeal becomes an efficacious and alternative remedy, it is a well-settled principle of law that when an appeal is being provided, by a statute or by the service rules, the appellate authority is required to look into each and every aspect of the objections so raised in the appeal. It is also very pertinent to mention that these appeals, it is also very pertinent to mention that a respondent bank is a state within the meaning of Article 12 of the Constitution. And under such circumstances, when a decision is taken by the respondents, there is a requirement for giving due reasons. Inasmuch as without reasons being assigned, it would result in the order being arbitrary and violative of Article 14 of the Constitution. From the materials on report, it therefore transpires that the order which had been passed and the resolution so adopted on 28/2018 contain no reasons. Apart from that, it appears that the learned the board of the directors of the respondent board have decided the said appeal in a manner in which a review jurisdiction is to be exercised. Inasmuch as the reason so assigned therein is that no new materials were placed for reducing the punishment. Therefore, from the above, it would be seen that the order, that the manner in which the appeal has been disposed of is not only not only smacks of arbitrariness, but also of complete non-application of mind. Accordingly, this court, therefore, taking into account that various factual aspects are required to be gone into, and taking into account that various factual aspects have been made grounds of objection in the appeal, is of the opinion that it would be in the interest of justice to direct the board of directors of the respondent bank to decide the appeal afresh by giving a due opportunity to the petitioner, by giving an opportunity of hearing to the petitioner. Mr. S. Todolan, senior counsel appearing on behalf of the petitioner, submit that in the meantime the petitioner has attained the age of superannuation. And as such, there is a necessity that the appeal be directed to be disposed of within a time frame. In view of the above this court therefore disposes of the instant writ petition with the following observations and directions. Number one, the impugn order dated the impugn resolution dated 28/2018, where the impugn resolution in agenda number 5, in agenda number 5, the agenda number 5, the impugn resolution adopt insofar as an impugn resolution dated 28/2018, insofar as agenda number 5 is concerned, is set aside and quashed.
Resolution. It is a resolution.
Therefore, say yes, insofar as agenda number 5, because the others may be impacted. Number 2, the impugn communication dated 27/2020, issued by the managing director of the respondent bank to the petitioner, is set aside and quashed. Number 3, the respondent bank, the board of directors of the respondent bank are directed to hear the appeal afresh, and in doing so, provide a due opportunity of hearing, a personal hearing to the petitioner. Next, the board of directors are directed to dispose of the said appeal as expeditiously as possible and not later than 4 months from the date of service of a certified copy of the instant order upon the managing director of the respondent number 3, respondent bank. What else?
In case he remains aggrieved with the decision of the appellate authority, he will be entitled to come back.
That you know, you are always there. Why should I give?
My lord, at times, my lord, the objections come that it
Why
is.
should I give a leave today? This is not an appellate forum. It's not an appellate forum.
Sometimes, my lord, the objections come that since the matter has been gone into, so as far as the report and punishment order is concerned, it will be res
You
judicata
have to
and all.
make out a case that there is a perversity later on. The above the instigations here, the records which were produced are returned. Nowadays, I take up the departmental proceeding as faster because there are a lot of people who are suffering. So immediately disposal is there. Because you see, these matters, it is very difficult for this court under 226 to touch on merits, loss of confidence. Huh? It's very limited scope. So the best is to remand it to the appellate authority, and if they do some fundamental mistakes on that, then
Picked at 2 p.m. Item 69. The one that we have filed on behalf of the state director, report number 2, on 13/5/24, page file of 66. Start. There are 8 documents. Submitted on 10, at about 10:30 a.m. on 10/4/2016. Gave birth to a child minor on 1:10 p.m. on the same day. And at 3:30, there was some complication because of want of blood. They were suffering from anemia before and after. And she was referred to was at a medical college. And there she reached at around 5 p.m. on 10/4/2016.
And to issue direction for payment of compensation of an amount of rupees 2 lakh to the petitioner and her family for the maternal death or the death of the petitioner's mother and the failure of the state public health system to protect her and the trauma caused to the petitioner and her family. It is relevant to take note of that the first two directions for software has already become effective, taking into account the passage of time. However, the question arises as to whether the petitioner would be entitled to an amount of any compensation as has been sought for in the petition. For deciding the same, this court finds it relevant to take note of the affidavit filed by both the respondent number 5 as well as the respondent number 2. In the same affidavit, it has been mentioned that the petitioner's mother was admitted at 10:30 a.m. on 10/4/2016 by Hospital Monthly Serial number 86. During that time, all findings were normal except mild hypertension. After getting all necessary care and treatment to the patient, to the petitioner's mother during the morning hours, she was prepared for conducting the normal delivery. In the evening, the medical officer examined the case and delivered a healthy baby at 1:10 p.m. without any untoward incident, and the baby was handed over to the mother and she was shifted to the postnatal ward. In the postnatal ward, normal, regular, immediate postnatal checkup was done according to the protocol and she was found to be stable. At 3:30 p.m. the patient party complained about sudden convulsion of the mother, and then as per medical protocol, resuscitation was done, but the patient did not regain consciousness and it was decided to send the patient to the nearest higher center, that is the FAAMC. What is the full name? Fakhruddin Ali Ahmed Medical College and Hospital for better evaluation and treatment. The government ambulance was contacted. However, that very point of time, the government ambulance was quickly with another patient. Under such circumstances, the attendants of the patient took a decision to hire a private ambulance as per their private ambulance. It was also mentioned that after resuscitation, the patient's vitals were stabilized for referral, fitness, and then shifted to FAAMCH. It is also seen from the affidavit filed by the respondent number 5, who is the superintendent of the FAAMC hospital, wherein it was mentioned that the patient was referred to the hospital on 10/4/2016 and upon being referred to the hospital on 10/4/2016, was admitted at 4:42 p.m. Thereupon, diagnosis was carried out, and it was found to be a case of suspected cerebral spelling the case vascular accident with severe anemia. It was also mentioned that various necessary possible measures were taken and necessary treatment was also given to her. But in spite of all efforts to revive, the patient expired at 7:45 p.m. on 10/4/2016 in the hospital. It is further relevant to take note of that these affidavits were filed on 29/11/2023 and 13/5/2023 and 29/11/2023. There has been no reply affidavits filed thereafter. Be it as it may, from the materials and report, it cannot be said that there was any case of a negligence which had resulted in the death of the mother of the petitioner. Considering the above, the question therefore does not arise that this is the case for payment of any damages on account of a constitutional tort. Accordingly, the instant petition stands dismissed.
Item 70.
Yes,
Was filed by the petitioners for their promotion, and since the last.
what promotion cases are coming here? I'm not taking up this. This is the matter before the to be bench. I'm only taking up.
Item 17.
You appeared in the another matter. It's 17. It's 17 is what? It's the same. Yes, sir. It's a matter of in 17 years. The other one? Earlier matter to কি? আগৰ matter to কি ইমান? 7-0. Oh, yes, that is what, yeah. It is 17. This is that matter, na? I have all these matters, other matters on this. The present institution has heard Mr. So-and-so, the legal counsel is hearing on behalf of the petitioner, and Mr. P.S. Bulwer is hearing on behalf of the railway. The present institution has been filed by the petitioner seeking a compensation, seeking a direction upon the respondent to pay compensation to the tune of rupees 40 lakhs approximately to the petitioner on account of the death of the husband of the petitioner number 1 and the father of the petitioner number 2 to 4. Indeed. Brother. What brother? Brother. Husband. His mother. The instant petition has been filed by the petitioners who claim to be legal representative of one Rakesh Kumar Sinha since deceased. Seeking compensation to the tune of these 40 lakhs on account of the death of late Rakesh Kumar Sinha in connection with the DBRT of the GRT of the OP by PE number 356 dated 26/11/2022 corresponding to Tinsukia GPRA U of the D case number 75 of the 2022. The facts leading to the filing of the instant petition is that the deceased, that is late Rakesh Kumar Sinha, was returning from school on 26/11/2022 when he met with an accident at kilometer 3/0-3/2 at 12:15 p.m. between JM of the EBRG to GRP of the EBRT and succumbed to the injuries. The petitioner thereupon submitted a representation before the Regional Railway Manager Tinsukia, as well as the General Manager Northeast Railway Maligaon, with a prayer to pay compensation against the death of late Rakesh Kumar Sinha, which as per the petitioner was caused due to complete violation of all the norms of railway crossing, level crossing at KM 3/0-3/2 in respect to the Tinsukia GPR's UP case number 75 of 2022. However, those specifications haven't done any redress. The petitioner had approached his court by filing the instant petition. Saying that pursuant to issuance of notice, affidavit in opposition has been filed by the respondent number 2, wherein it has been categorically mentioned that there was no form of any negligence which led to the death of late Rakesh Kumar Sinha. It was further mentioned that the death of that the unfortunate death of late Rakesh Kumar Sinha was due to illegal trespassing on the railway track at the crossing at KM 3/0-3/3 was unauthorized. It was further mentioned that under Section 147 of the Railways Act 1989, any person found trespassing the railway track will be liable for prosecution which entails punishment with imprisonment for a term up to 6 months or with fine of ₹1,000 or both. Under such circumstances, it was therefore stated that a question of payment of compensation does not arise. To the said affidavit in opposition, a reply has been filed to the effect that the respondents have duly admitted that it is a death case of run-over and knockdown as per the station master's report, as well as the police report submitted by the in charge, Dibrugarh GRPO. Under such circumstances, it was also stated that the statements made that late Rakesh Kumar Sinha had made illegal trespassing on the railway track is contrary to the report of the station master and the police report. It was also mentioned that the untoward incident which had taken place was due to illegal trespassing of the railway track. Therefore, on the basis of the materials in the report, inquiry to the learned counsel appearing on behalf of the petitioner as to how the instant proceedings should be maintainable, taking into account that the fact as to whether there was illegal trespassing or not are questions of facts which can only be adjudicated in a proceedings wherein evidence can be led. Mr. C.P.S. Burla, the learned counsel appearing on behalf of the railways, submits that the petitioner ought to avail remedy before the Railway Claims Tribunal in terms of the Railway Claims Tribunal Act 1989. The learned counsel appearing on behalf of the petitioner submitted that the question of approaching the Railway Claims Tribunal does not arise, taking into account that jurisdiction of the claims tribunal is not take into account a situation or take into account whether Railway Claims Tribunal Act not it's not the right taking into account that such jurisdiction can only be exercised. if a case falls within the ambit of section 13 of the Railway Claims Tribunals Act 1987, he therefore submits that the writ proceedings herein is the appropriate remedy for which the petitioner has approached the court. Upon hearing the learned counsel and upon perusal of the materials in the report, it transpired that the jurisdiction from our power and authority of the Claims Tribunal have been categorically mentioned in section 13 of the Railway Claims Tribunals Act 1987. From a perusal of section 13(1)(a) and B, and from a perusal of subclauses A and B of section 13(1), as well as subsection 1A and 1B of section 13, it transpires that the dispute in the present case would not be covered within the whole of section 13 of the Act of 1987, inasmuch as the dispute herein pertains would not come also inasmuch as the dispute herein arises on account of an accident which took place while crossing a railway line by a person who was not a passenger. Within the meaning of section 124 A of the Railways Act 1989. Under such circumstances, the question of the petitioner approaching the Railway Claims Tribunal to claim compensation does not arise. Be it as it may, a question, however, arises as to whether this court would be in a position to exercise its jurisdiction, taking into account that there are disputed questions of facts as to whether the late Rakesh Kumar Sinha had illegally trespassed upon the railway land, railway lines, railway tracks, which have been averred by the respondents in the affidavit in the position. In the opinion of this court, such factual disputes can only be adjudicated in a proper forum wherein evidence can be led. Accordingly, as there are disputed questions of facts involved, and apart from that, the question of payment of the question of determining the compensation has also to be decided on the basis of evidence. Accordingly, this court is of the opinion that this is not a fit case where it should be entertained under Article 56 of the Constitution, for which the instant petition therefore stands dismissed on being not entertained. Because Peter is, before parting with the report, this court, however, is of the opinion, however, makes it clear that the dismissal of the petition on being not entertained shall not preclude the petitioner to approach the competent civil court seeking compensation if they are agreed. In addition to that, this court also observes that the period from 24/8/2023 till date be excluded while computing the period of limitation. With the above disclosed.
Then 17.
Yes, what is this? Litigation. Promotion from?
From
As per law is settled, they are regular against personal post.
Huh?
They are regularized against personal post.
Regularized against?
Personal post. Personal to them also. So they are escalator and they are not entitled to promotion. Law is settled.
Why you are not filing a petition? You don't require.
Only before. Otherwise I will find out.
No, you say that. You don't file. No problem.
I will find out.
But you have taken time in 2022.
Thereafter, the right to step up. I will find out.
What are you saying that they are not entitled to promotion?
Yes.
Why?
Now, if you try to appeal,
Why they are not entitled to promotion?
they regularize against personal post. Personal post will be there till they relinquish the post.
See their appointment.
The time. Page 14. Second paragraph.
So they are not being cadred.
Not this case.
So their promotion does not arise. Okay, madam.
Plus, the petitioners were already filed their petitions earlier also, where the honorable court has directed to give them promotion as they have already completed their 25 years of service.
How can they be promoted? They are not in the cadre. In fact, the order which the personnel is only for the professional only if it is done for promotion or at the last moment if it is done. But if you are regularizing somebody, you have to bring them within the cadre. That order is wrong.
Their services were replaced effect from 22/7.
But the order is wrong. The post of personnel to the incumbents concerned who are holding the post will be abolished as soon as the concerned incumbents relinquish their post. So under such circumstances, you have no right. You may be promoted against all your persons. You want to go on serial number 2. Here there are in item number, page number 16, there are 16 persons. Or so many persons. You want to go up the ladder on these numbers, it's a different thing. Otherwise, you have no right. In fact, that order is wrong. You should challenge this order. Office order needs to be challenged that you can't make it personal to a yard. You are taking away somebody's right. And in fact, this is never done. Irrigation, na? Irrigation does all this. This can be done. This order is on. What is that? Let us dismiss something in bench. Some that is fine. Oh, we dismiss. Terms of the limit council is here on behalf of the commissioner. And the NN, the limit council is hearing on behalf of the department. The petitioner, how many petitioners? The petitioner is very. Five petitioners.
Five.
Have approached this court seeking direction upon the respondents for consideration of them to be for their for them to be considered for promotion to the next higher post. From the material from the court, we see that the petitioners herein where the services of the petitioners herein were regularized by an order dated 6/10/2005, whereby the petitioners, whereby the posts to which the petitioners were regularized were personal to them. And with the stipulation that such posts shall be abolished as soon as the concerned incumbents relinquish their posts in any manner. Mr. N. Upaida, the learned counsel appearing on behalf of the petitioner, a respondent litigation department submitted that the issue involved in the instant proceeding is well settled by the judgment of the learned division bench in the case of Dilip Taluda and others versus State of Assam and others, reported in 2017 to GLP 135. This court had duly taken note of the state judgment. Paragraph 7 to 10 of the said judgment being relevant are reproduced here in under. In view of the said, in view of the observation, in view of the settled position of law as set by the, in view of the settled position of law as held by the learned division bench of this court in Dilip Taluda Supra, the petitioner, the instant petition so filed by the petitioner is meritless, for which is devoid of any merits for which the same stands dismissed.
18.
What is it? What is that? What is he challenging? Now, did the petitioner succeed in the first round? Huh? Huh? In the first round. What about the second? Then? What happened?
The status report is also done.
What happened? Some affidavit is filed by respond number 2. We respond number 2.
But you know, the separate of this.
What happened?
Seven.
Oh, how do you say that he was selected? Results were not published. Ah, forget about the petitioner. Petitioner is not there. But as per your version,
What's the
para 7.
Yeah, para 7 is very clear that the result was not declared.
None appears on behalf of the petitioner on call. Mr. J.K. Gustam, the learned counsel appear for the district administration, and Mr. A. Bachchaji appears on behalf of the revenue department. The case of the petitioner herein, in short, in brief, is that the petitioner had in pursuant to an employment notice dated 13/7/2020, appear submitted his application for filling up the post of Daugura. On 10/9/2020, the petitioner was called for interview to be held in the office of the respondent number 3 on 18/9/2020. Thereupon, the petitioner was interviewed on 18/9/2020, and a police verification report was sought. Subsequent thereto, the petitioner was issued another fresh call letter dated 10/9/2021, issued by the respondent number 3, intimating that the earlier result of selection for the post of Gambura for the village in question was cancelled, and the petitioner was required to face the interview board again on 29/9/2021. It is under such circumstances the petitioner had approached this court by filing the instant writ petition. Pursuant to the filing of the instant writ petition, an affidavit has been filed by the Deputy Commissioner Lakhimpur, wherein it has been mentioned that there was no results published in respect to the earlier interview. And as such, also, it was further mentioned that the result of the interview held on 18/9/2020 for the post of Gambura would not be declared, as the then selection committee members were transferred due to conduct of the assembly election in 2021, which led to the incompletion, which led to the whole interview process being abandoned. And accordingly, on 10/9/2021, the respective candidates were notified regarding the cancellation of the earlier interview and to attend on 29/9/2021 for fresh interview. So, taking into account the above, this court is of the opinion that the petitioner herein cannot claim a right on the basis of an interview being held without the results being published. So, under such circumstances, as the instant writ petition does not disclose any that instant petition is devoid of any merits, that's the petition stands dismissed.
19. Here, accordingly, my lord, proposition of 200 foreign tribal father. So that was not approved by the government of India, the demand they blocked. Then petitions were selected for appointment as the LDA, etc. But ultimately, nothing came out because the tribunal didn't take off.
As of now, whether the select list is there,
So it is an extended. It is an extended because extended by law.
Page number 4.
yes, why, affidavit, why haven't you filed, have you filed affidavit?
This certificate has been filed in 2021.
Yes, what is your stand?
And stand is also that there was some matters pending for the Supreme Court. As such, 200 members of foreign tribunal will not be posted to carry out the original matter and are being attached with the existing 100 foreign tribunal. Hence, the process of appointment of ministerial staff could not be decided. Para number 4 of our agenda. Then the second part of the same para is that the monitoring bench of High Court is regularly monitoring all the activities arising out of issues related to foreign tribunal.
There are two other cases. It's another two. Resolution number 3446 of 2021, 4344 2021.
So they have given due reasons. You don't have a right to be appointed.
They're contextual also. They're contextual.
Go for a fresh. First, the requirement has to arise. There's no appellate tribunal, what is there? What is your right, Mr. Sharma?
200 in the.
No, Mr. Sharma, what is your right?
No, in appeal, you were selected.
You
by
were
court.
selected, okay. But the entire edifice for why you have been selected is gone.
Approval.
It's something like holding
This proposal for
holding some festival out there in Brahmaputra, and the Brahmaputra later on, there is a flood. Huh? But I remember that there was something, there was a festival in Brahmaputra, right?
Yes, sir.
And everything got washed away. It's something like yours.
That 200 tribunal didn't take out. So our evaluation.
That too for contractual appointment. So there are no post or nothing. We will have it later on. You have a case now. How can you enforce directions for it? And they have given due reasons. Dismiss. What liberty for what?
Then they, okay, then we tribunals coming up, we make a give appear in the interview.
Mr. R.P. Sharma, the Learned Senior Counsel assisted by so-and-so submits that taking into account the stand which have been taken, taking into account the stand in the affidavit in opposition filed by the respondent number 5 to the effect that in view of the pendency of the proceedings before the Supreme Court, no steps have been taken for appointment. The petitioner would not like to press the instant petition for the time being. I would not like to press the instant petition. We, however, submit that after the disposal of the matter, or after such directions that may be passed by the Supreme Court, if the petitioner is agreed, liberty may be given. Taking into account the above, the instant petition stands closed on withdrawal. However, the petitioner would be at liberty at short form.
Three.
Yes, Mr. Bhattakur. What are these matters?
Petitioners were inflicted punishment of
Huh?
they were inflicted punishment of dismissal from service by the this North Kasar Hills Autonomous Council of Service.
All the register from, joint register from a bench only. What is this? I thought 1, 2 bench 3 matters are coming. One after another, I'm getting these bench 3 matters. Why? My roster was specific, isn't it? Let's see my roster.
3, 4, and 5.
Only the hearing matters. Now this is being happening. Let me see my roster. Why all bench 4, 5 matters are given? The repetition. Repetition for relating to state government employees only cases pending at hearing stage. With petitions relating to service in local bodies only cases to hearing stage. With petitions civil relating to service and defense only relating to this. Otherwise, I'm to take bench 4, 5. What is this? How many advocates would suffer? All these matters have come up. Yes, anyways. In he comes, what is your case? Your case, good case or bad case?
Lordship, as far as my understanding goes, Your Lordship, it's a good case.
Okay.
I have 2 grounds, Your Lordship. The procedural
You have urgency.
urgency in the sense, Your Lordship, since 2018, I am here out of service.
You have been
Out of service
since
since dismissal of
Dismissed. dismissed how?
Dismiss, Your Lordship, Your Lordship, initiated an inquiry, Your Lordship. And after inquiry, punishment for dismissal was given, Your Lordship. And my specific case is this, Your Lordship, that the procedure has not been followed. The specific charges are not sent, number 1. Number 2, inquiry report was never furnished to us. And number 3, Your Lordship, that is, even assuming everything is done properly, Your Lordship, this, this punishment is disproportionate. These are the 3 grounds. I am. My case.
But Mr. Kothakar, the problem is, yes, I can't do anything more than that. Means if I fix it another day, for hearing also it won't come before me. I understand your predicament. You must be saying that rule line has not been followed. Let's see, that must be okay. Rule line has not been followed and the punishment is disproportionate to the charges. Means I have to either dispose it or now.
I need it.
So what do you want? Let's see if a rule 9 has been violated on the future. In our bills register rules.
The petitioner here also in WBC 5444, exactly the same
5474 I'm taking up.
law 54. You'll also may kindly take up 5478.
Yeah, 5478. Yes. Yes, yes. You come. Tell me, my roster was specific to only bench 3 hearing matters. Hmm. Why are all these bench 3 matters are before me? These are all bench 3 matters. Most of matters also. And these are all other matters. These are all bench 3 matters. Isn't it bench 3?
Bench three.
Or bench 4? Bench 3, no? Because I have taken 3, 4 are the bench 3 matters. For admission. Okay. Yes.
Now, what has happened here also? In the year 2017, there was a corner also held by the employees of the autonomous council.
Just 1 minute. If they have taken for how long? Ask me, how long? Only for today or what? For how long is my administrative permission is there? For how long? We take it up at 2. Tomorrow, meetings are complete. List the matter tomorrow at 2. So this will take other matters. 24th.
So benefit matter. However, Lordship, meetings are completed, Lordship. I have submitted filed my affidavit in reply. But after that, Lordship, they have on 3 occasions short time on the ground that they want to file one affidavit after seeking instruction. And saying that I have made some new facts in my affidavit in reply. But till then, Lordship, they have not filed. On 11/9, they were even given last charge. Seek instructions if any and file any affidavit if they want.
Mr. Deka, you are paying for 2 people.
For the APDC.
What is the matter about?
Promotion. Date of retirement is filed in petition.
Date of?
30th of September, he retired. On that day, petition was filed for getting promotion.
We retired.
Yes, notional benefit. He'll get notional benefit. There was a vacancy. He was not considered against that vacancy.
When did the vacancy arise?
Vacancy arose on retirement on retirement of an Othul Das on 31/12/2019. 31/12/2019 in the post of assistant manager.
And when did you rise?
Retired. Retired. 30th of September 2021. After 2 years.
The vacancy arose in 2019.
I retired 21.
Then
I have a claim against that vacancy, Lordship. I have a
is the claim, I don't know much, but tell me whether there can be a right to be promoted.
right to be considered against that constitution.
Different. You were there to be considered if you had filed the petition at the right time, this court could have issued a writ in that manner. But as of now, when you have retired and on the last day of your retirement, you file this petition for seeking promotion, how would the court pass an order? Tell me.
If I am considered for promotion with effect from the date of existence of vacancy, Lordship, I will get benefit notionally and my
But
pay.
is it a mandate that from the date of the existence of the vacancy, one has to fill it up?
Yes.
What
In
is that?
respect of
Show me that. You have a right to be considered on that day.
Yes.
Because if you come within the zone of consideration. But the fact that that is one other aspect, but you had the right. Why did you wait till the day, last day of retirement? Why?
Lordship, he submitted.
Take an adjournment. Else dismissal. Which one? You don't have a right.
I have judgment to the different.
Show me. Let us also be knowledgeable. Right to be considered for promotion or selection or whatever may be, promotion is a fundamental right. There's no quarrel with that.
2004 18645.
Huh? Which one?
Para 7. Para 7. 2004 18645.
Promotion, we fail to understand how to How does it help you? I hope you understand my specific query. My specific query is, there's no quarrel that you have a right to be considered for promotion. The right to be considered for promotion arose on the date on which a vacancy arose. And you came within the zone of consideration. Fantastic. But why did you wait for 2 years thereafter? And then on the last day of your year, you filed a petition seeking give me the promotion.
Lordship,
And whether there is any violation, anybody else has been done so.
nobody else was there. But had it been a case of direct recruitment, Lordship, it was they were at liberty to keep the post vacant. But since it is a case of promotion, they cannot keep a promotional post vacant when the person in the feeder case is feeder post is eligible and is waiting for promotion.
But why did you wait?
Right in the article 14. So I
Remember, you're right on the Article 14 is there, but the Article 14 is dependent on delay and latches.
but the right was not.
Why on the last day of the, why didn't you file immediately thereafter? Did you submit a representation immediately?
Vacancy continued on the date of arrows arising of vacancy till the date of my retirement. It continued. Vacancy was continuing. It is
So
not.
why
that
didn't
it
you
was
file
filled
a
up.
repetition? 2 years. Why did you file on the last day?
But the vacancy was there. Vacancy was there. It was not there. It is not there. It was filled by some other person and third party writers actually. Then it is washed away. It is not that party. Vacancy was continuing. It was kept vacant.
Show me that it is the duty of the state to fill up the vacancy. A judgment to the. And show me that it is the incumbent duty of the state. Because you want a mandamus. Mandamus has to be on the basis of a duty being there and duty being not performed, this court issues a direction. But show me that.
In judgment.
When? 2 o'clock, 4 o'clock.
Next week.
No, then why I asked you to take an adjournment? Okay, at the request of the learned counsel for the petitioner matters and adjourned to be listed when?
Next week.
What?
Next week any day.
I don't have the jurisdiction. But you didn't hear, you couldn't phone.
Maybe on
My jurisdiction is very limited till 14.
maybe on
You ask for a bench for fine, I will be giving you. Not. I can give you in the month of January.
25th November. 25th November.
No. The request of the learned counsel for petitioner matters can adjourn to be listed of 15 minutes. Yes, sir.
Yes, my lord, they are pressing on the alternate remedy methods that the matter be delegated to the arbitrator.
What are you asking?
My lord, I'm asking for, my lord, what has happened, my lord, this matter. Although, my lord, compensation was paid, but the, my lord, compensation under the 2013 Act was not paid. Schedule 1.
Like that, judgment of 2022.
My lord, give me some time, I'll examine the affidavit.
You are clear, directing the responsibility for this case, relation, education, other countries.
And also 12% in terms of 33.
You get many things.
My lord,
But
just
they
give me
pass a direct,
one opportunity, my lord,
not necessary.
I'll reply, my lord, kindly.
For what?
The affidavit opposition, I have not gone through the affidavit.
Not necessary. I am also not looking at you. I am only looking into your prayer. Your prayer is very clear. You are agreeing to this.
Just 2 days time.
No, no. It's the people who are here on behalf of the National Highway Authority.
They are better in alleged detail.
And I can
They of the party, but it is main party. We are fine.
You are?
They say of the alleged detail.
whom are you appealing?
What we are appealing, but the affected party is NSA detail, we have filed NSA detail.
And I think I appeal on behalf of the district administration, including the Hala. The petitioner hearing is being by the order dated 30, order passed under section agreed by the determination of compensation in terms by the competent authority under section 3(1) of the National Highways Act 1956. On the ground that the respondent authority have the competent authority have not included the solation for my interest as well as other compensation components as stipulated in Schedule 1 to 3 of the right to fair hearing by Mr. P. Monto, the learning counsel is hearing on behalf of the petitioner, submitted that the petitioners are entitled to the said amount, taking into account the very settled principles of law laid down by the Supreme Court in the case of Puerto versus Nagaraju versus Puerto, reported in 2022, 15 and 16 page 1. And further submitted that in terms of section 2G7 of the National Highways Act 1996, it was incumbent upon the competent authority to arrive at to determine the compensation as the law. He therefore submitted that this is a fifth case where this court ought to exercise the restriction in the instant proceeding. Performed from Mr. Srivoli, appearing on behalf of both the NHI, as well as NHI submitted. But if the petitioner is agreed with the compensation, the petitioners had the remedy under section 3.5 of the National Highways Act 1956. And answer, the petitioner this court have taken, have heard the learned counsel appearing on behalf of the party that have also carried the materials from the court. This court further takes note of section 3.5 of the National Highways Act 1956, which categorically mandates that if a person is any of the parties to the proceedings are agreed by the quantum of compensation as regards the determination of the quantum of compensation, the matter can be referred to the arbitrator. Consequently, this court is not inclined to entertain the petition in view of the availability of an alternative and effective remedy. Accordingly, this court therefore disposes of the petition with a direction, with a liberty to the petitioner to submit a representation to the competent authority, who shall, upon receipt of the same, shall forward the same to the arbitrator appointed under section 3.5 by the central government. In the same proceeding, the petitioner will be at liberty to raise all the issues as regards the inadequacy of the compensation, including the well-settled principles of law and stated here in the with the above things, indication stands disposed to.
And also the guidelines, the arbitrator will take into account the guidelines issued by the ministry whereby it has been clarified.
And I'm giving you that judgment now.
Yes, Nagaraj,
That judgment you will get.
And one more thing I'll just point out, my lord, that this PG payment was made pursuant to a judgment of this honorable court. I have annexed it, my lord, because it was not paid before. So we approached the honorable court, and after the judgment of the honorable court, the PG compensation was paid. So that may be next.
Which one?
The petitioner, initially, although he was issued, but the payment was not deposited. So they approached the honorable court, and the honorable court, by a judgment dated 18/12/2018, and directed the Kala to release the money, and thereafter the money has been, the amount has been released. Deeply of that.
26.
Well, these three petitioners before your lawsuits were initially appointed by the Government Regulatory Council on the advertising of this post. This post was my lord 20 years judicial assistant grade 3. Grade 4, they are competent to advertising. I have been, my lord, really it is the competition was there. I was selected and I was appointed. Now in December 2021, there was an order that was passed by the government stating that he has qualified because of the eligibility criteria that 5 years of continuous service, they can apply for the post of traffic inspector. Accordingly, we applied, it was forwarded to the authority concerned because we were working under ministerial cadre
under directorate. Now, there was a writ petition which was filed by a candidate who doesn't belong to the directorate of the ministerial cadre. He belongs to the district commissioner, district and commissioner establishment who was working under a food supply, because there is a branch, food and civil supply department branch. He comes up before this court by a writ petition. He says that it is not that why you are not considering my case. I may be not under the ministerial cadre. I am under the food and civil supply of branch under the district commissioner establishment, which has been amalgamated. Because in that establishment, I have been taken by district commissioner, deputy commissioner to another wing. So that was not my fault. Because you require 5 years continuous service in the post of sub-inspector under the amended rule of 1989. 1989 rule says 75% by direct recruitment, 25% by promotion. He said, I am eligible. Then it came up before this court. Court considered. Court said one thing in this court, in the writ court said that yes, these are two different ways. Because court says you cannot get the benefit under 11.2 because that is under a ministerial cadre. You are not under ministerial cadre. But however, if you are not under ministerial cadre, that particular 5 years continuous service may not be applicable. It is left to the government to consider the case. Now, accordingly, as I have been told, government has considered this case. Why I have approached this honorable court? Because after the judgment was passed by this court, kindly see a notification at page 77, last page. This the government has issued, and which they have withdrawn the notification letter dated 2012-2021, which your lordship will find at page 57. 57.
You are referring to the judgment at page 68.
68 is the judgment. Yes. 68 is the judgment. Kindly see paragraph 12 at page 73.
Okay. That I have looked into.
Lordship got it? Yes. So the court said that it can be considered. And accordingly, as on date, we have no remarks.
How can he be considered?
He has considered, if, as per my opinion, also, he cannot be
They
considered.
are not in the cadre. How can they be
Yes.
considered?
My lord, government, I will tell you also. Government has filed a review application to review this order. Review was discussed by this court. Now, against that, they said, we are preferring a second appeal. Now, I don't know to what extent, but in the meantime, government considered the case and he got.
But wouldn't it be violation to rule 11.2?
But at one point of time, because of scarcity of the person, there are some persons who considered for the ministerial cadre of the district amalgamated office. Somewhere there are some instances that long time. That is on that case, ultimately the person is dead. But here, but I have a clear. But the page 68 also seen the order. This is
No, here the promotion to the post of sub-inspector is in terms with 11.2.
11.
So 25% of the vacancies in the cadre of sub-inspector of the year shall be filled up by promotion from the select list prepared for this purpose under Rule 2 of Rule 13 from amongst the ministerial cadre
Ministerial cadre of
who are of outstanding ability and have rendered 5 years of company in the ministerial cadre on the first day of the year end. The ministerial cadre shall include lower division assistant, so and so, in the office of the director and chief representative in the district of the government. So under such circumstances, how can somebody else who is not of that cadre be brought in within the?
that is the view of the department. But ultimately, there was some, because of the level not there, clear. Some persons from the CFA, they were considered. But what I would like to submit there, but the page 68 lottery is promotion process was of 2019. And ultimately that has calculated finally the government has taken a decision that following the earlier instances, he has been given the benefit. But in respect of page 77, the notification which has been withdrawn. That is on the challenge in this petition before the honorable court. But the petitioners, they
Which notification has been withdrawn?
page 77 in the WP message.
This is being challenged here.
Yes,
That has been
This is-
withdrawn.
this is cancelled, this cancellation we have changed. For this process, we have started subsequently in 2022, in 2021. So this is a separate process and now my instruction is that the government has now taken steps for amendment in the rules. And the subsequent, they have also taken some steps. Those are my telephonic instructions, but I would like to report some type of technically one instance so that I can bring the instructions on. Because the amendment they have already put in, and this 2021 process they have already done.
Because this, why we came to
This
court, I
ultimately,
just
if
tell the court, 77 was the WP message which was issued. They said, on a judgment passed by this court, that judgment, the only judgment passed by the court, that is why at page 57 we have withdrawn. We said that what connection you have to a judgment? Kindly see at page 77. Number so and so in the light of the judgment order dated so passed by Honorable Guwahati High Court, State of Assam so and so, which is regarding recommendation eligible applicant for promotion in the post of sub-inspector from so and so, as per then prescribed matter may be treated as cancelled. And we are genuine 11-2, we are from the directorate, and today you have withdrawn, and my promotion is due. And we are entitled to the promotion by 11-2 of the student civil supply rules under 309 which you have made. That was our case, my lord.
Filing an appeal against.
but in that particular case, no appeal was filed. Because in the review, while discussing of the review, the honorable court has also observed that there will be instruction from the government in the year 2014 that they will go for the amendment until the amendment that is approved first, they will adopt the argument. In fact, they have said that they have already taken steps for amendment in the rules because there is no clarity in 11-2 that whether the ministerial cadre of this particular district office, they will be amalgamated office of the deputy commissioner will be considered on. It has been argued that the person who are in the ministerial cadre of the amalgamated office of the deputy commissioner, they are to be considered.
No, 11 to say something else.
Well, there is no clarity.
No, 11-2 is clarity.
Well, we said that.
No,
the
11 to
77
page 72, can you see?
well, we said.
25% of the vacancies in the cadre of sub-inspector of food and civil supplies will be filled up by promotion from the selectly prepared. For this purpose under sub-rule 2 or rule 13, from amongst the ministerial cadre who are of outstanding ability and have rendered at least 5 years of continuous service in the ministerial cadre on the first day of the year in which the selection for promotion is made, the ministerial cadre shall increase the post of so and so, so and so, so and so in the office of so and so. Meaning thereby, it is inclusive definition.
But that is our standard 70 rules is applicable only for the directorate. But it was being interpreted, it was being argued by the petitioner in that case that this also includes the covers the ministerial person who are working in that particular branch of the civil supply branch of that this year. Deputy commissioner. But the review order and the subsequent steps taken by them, and those are required for.
No, you, please, my lord. Yes, then, at page 91, Mr. Nath appeared. Kindly see at 91, what we argued. Affidavit in reply. Affidavit in reply at page 91. The wrote case, review petitioners, counsel submit, post of sub-inspector to the have to be filled up in terms of 11-2. Rule from the ministerial cadre of directorate. As the opposition of one did not belong to ministerial cadre of directorate, he could not have been promoted to the post of directorate, even when he promoted. And today they are saying, we want to amend the 11-2. They were frustrating our case.
No, 11-2, we are making it verified. We are making it very clear that it will be applicable only for the department, the director of food and civil supply, not to the others.
No. In fact, see,
Kindly come
there's a difference.
page 95.
And includes, if the word is and include, then it is an exhaustive definition. But shall include makes it not a.
Kindly come to page.
Anyways,
Page 95, para 10.
what do you want now?
So I pray for one in time so that I can update the, I can get the written instruction from the author and then I have to bring.
After filing so much of affidavit, you want
No,
written
no,
instruction.
no, there's affidavit doesn't file like that.
But anyways, why have you stopped?
Why? We have.
Why have you stopped the promotional things?
Page.
Yes, somebody may be there or not. The petitioners are not challenging that that person should not be
Yes,
brought in.
correct.
That is not
They are
the
not-
case.
they are
The
not-
petitioner's simple case is that we are now eligible to be promoted to that particular post. We come within the zone of consideration, kindly consider us for promotion. That's the simple claim.
The author gets for it proper that before we proceed with the process, these things are to be clarified, then they will be. There are some. So they should have stopped promoting that person. And our is a judgment case 2021 and today is 2024. And time is going on. Time we will retire and thereafter, my lord.
And we will say that we are sorry, we are too delayed.
Yes. The petitioner number one is 40 years old. Oh, what about it? It is 40 years old, but even the time is running.
Anyways,
I'll-
when do you want?
But, we didn't want to give. We didn't want to get the instruction.
In 7th of November 2024, in the meantime, Mr. Dina shall obtain the instructions. Mr. Dina submits that certain instructions are required in the instant matter. On the other hand, the Dina, the legal counsel, senior counsel, appearing on behalf of the petitioner submits that the petitioner hearing are eligible in terms of section 11(2) of the
Assam Food and Civil Supply Service Rule 1977.
and as a petitioner come within the ambit of the zone of consideration, the petitioners have to be considered for promotion, which is a fundamental right as held by the various judgments of the Supreme Court. The learned senior counsel supported that in view of the inaction on the part of the respondent authority in carrying out the said selection proceedings, the petitioner will need have approached the spot. Mr. Dina, the learned counsel appearing on behalf of the state, submits that he requires certain instructions to be taken. This matter until 7th of November. In the meantime, such instructions to obtain it to be brought on record by filing an affidavit.
Clear. 57.
Yes, what is this?
In this case, I'm carrying on the first number 1.5 years. So I'm the, I will be executive officer of the municipal board. And what the instructions will also and as far as the instructions are concerned, the protection that he has not been paid the money is not correct. It is on the record by the company.
Your Lordship, kindly look to the order dated 24 to 2020.
That I am looking for my order. Yes, have you paid the amount?
You paid the amount, Your Lordship, and
You were directed to pay the amount, pending salary.
that is the thing, Your Lordship, this.
Why, on account of area salary, the CPF, gratuity as well as other pension benefits not paid?
Subsequently,
This order was passed in 2023 February, and we are in the month of December, you want the next date on 25th. Why will you file your affidavit?
That's what, let me find, initially there was some confusion and also to see that, I had initially appeared on December 23. Subsequently, there was some registered, matter was sent up by registered for the same respondents. In the last occasion, you know, to see the order that, it was observed that GMC and the respond number 2, 4 and 5, they were given by registered post and all. But in any case, you know, I have received the instruction by which it is shown that, furthermore, they find an additional affidavit saying that 33 lakh rupees is they're claiming. This is not the case, Your Lordship. We have paid the money, and Your Lordship, there is even the instruction, there is even one, not after the filing of the case, but prior to that, we have paid the money, and on top of that, there is even an instance where we gave the money to him by check. He refused to accept the money. Then we sent it via mail, post, and then he encashed the second.
Anyways, when are you filing your affidavit?
Lordship,
No further time is going to be given, otherwise we will go on the doctrine of non-reverse.
no, I understand. But Lordship, I would also like to get some, there's one other aspect of this matter.
No, there is no other aspect. After 2 years, it cannot be a aspect of the aspect. A person is suffering on account of non-payment of the dues by you.
There is a criminal case pending against him, that's why.
So what? A criminal case is pending, has been only accused. He's not, you may pay him a provisional pension, nothing
No,
more
no,
than.
he's not entitled for provisional pension, municipal board, or CPF and all, but not provisional pension.
Then,
Other,
so what criminal case is pending?
regarding this only, regarding his, some misappropriation of money during his tenure in service.
Then, have you initiated any departmental proceedings?
Not, no department.
Then,
but criminal
how
code.
can you stop? Then, criminal proceedings, if there is a judgment being passed, then in that case, if the rules permit, you may do whatever may. Otherwise, you cannot. Criminal proceedings going on doesn't help. There has to be a, see, there is a mandate. These are not boundaries of the state. The state, in spite of how many
Respond number 5 only, not the municipal board officer, only the executive officer I can represent because that should be presented by the private. Respond number 1, 2, and 5. 5 is the executive officer of the Howling Municipal.
the Howling Municipal Board functioning,
Party is initial. Yes,
is functioning.
I talked to the.
They have a board. Then, well, you have no business now.
That is only the executive officer. That is one of the problems here. I am the executive officer. I am representing the executive officer who is a government servant. That's why only I can represent. Otherwise,
Who appears for Howling Municipal Board? They are the main person.
instructions have come from the executive officer. But so far as the
Executive officer will only come into the scene when the government appoints him for specifically during the dissolution of the board. If the board is functioning, then what role does the executive officer have?
but otherwise, they have impeded both the executive officer as well as the Howling Municipal.
Maybe at that point of time, the Howling Municipal Board was dissolved. Maybe not now.
So then, what has happened is I called the person, the executive officer, the lady today. She then because of
I'm
certain
appealing for the director of municipal administration. Okay, on their behalf also you are responsible.
yes, 1, 2, and 5.
And whoever appears service report in the first stands complete. So it's 4 and 5 is complete. None represents on behalf of the person when the matter is known. So under such circumstances, we will consider that there is no other.
Actually, no, that is what I'm saying. 4 is different, 5 is different. I am representing 5 also.
5 does not exist without 4. You see, the Howling Municipal Board continues to function. It remains, but the board being not there, it is being taken over by the executive officer. Now here the executive officer is there. Maybe at the time, his jurisdiction is only at the time of dissolution. Once the board forms, the executive officer loses his jurisdiction. But the fact that the executive officer was taken up at the time of the dissolution makes it also compels the Howling Municipal Board now to take it because there has to be a continuation. Otherwise, tomorrow the executive officer has done some other acts and the board suddenly says that no, all these will let us do it. Can happen like that. Value happen. The petitioner hearing is agreed by the non-payment of the bills to which the petitioner is entitled. from the respondent number 4 and 5. This court, as far back as on 2023, had specifically directed the respondents to bring on record their stand by filing affidavit as to why the petitioner would not be entitled to to his views, which would be the area salaries, CPF, as well as gratuity. No affidavit has been filed in spite of a passage of more than 1.5 years. Mr. C.S. Hazarika, appearing on behalf of the respondent, submits that he would like to file an affidavit. He has got instruction and he will be filing his affidavit. The respondent will be filing the affidavit. This will list this matter again on 27th of November 2024. The affidavit will be filed by 25th of November 2024 without fail. It is observed that in the circumstance no such affidavit is filed, this court shall be compelled to decide the instant dispute on the basis of the materials already available on the court.
Step 28 and 29.
Thank you, Lord. So there are two cases, my lord. First one is I'm appearing at number 28. This case, our pair is very limited, my lord. That during the, my lord, also holding the land, one after another, they are issuing another notice on behalf of respondent number 6, saying that this is a land, my lord, which ought to have been allotted to respondent number 6. And latest position is that, my lord, there was an inquiry conducted by, my lord, register, and report was submitted to deputy commissioner. Respondent number 6 didn't appear. And
What
that
is allotment of land?
my lord,
Who appears in W1638?
6, 8, I'm appearing,
Okay, now you are asking for allotment of what land?
but my lord, land which is being held by us
What?
for last 22 years
Fantastic, but who is asking? But you are asking the land to be allotted by whom?
by government.
Oh. Then did you submit any application for allotment?
Yes, that is pending, my lord. That decision is still pending. In the meantime, respondent number
And
7.
how are you asking for 8 bighas, 13 lessons?
Yes, my lord.
You are only entitled to 1 katha, 5 lessons, if it is in Nagaon.
But we are the cooperative society.
So what?
My lord. The cooperative society.
Show
is-
me under land policy, you are entitled to so bigger land.
My lord. Basically, my lord, we are having a godown, an office. We don't have any land. The land originally belongs to, my lord,
Then
one.
buy a land. Buy land somewhere. You cannot come about here and ask that I want 8 bighas, 13 lessons of land of dark numbers, so and so.
My lord,
And where is that land? Land is where? In Hodai town?
my lord, question is not, my lord, but the timing, my lord, this is not the issue involved in the writ petition.
No, you are asking for a
Issue is,
direction.
my lord,
No, Mr. Prakash, you are asking for a direction from this court that I will direct the state to allot up for a particular plot of land measuring 8 bighas, 13 lessons. Is it permissible?
you know, once we have approved the government, is it responsibility of the government either to take a decision in our favor or to reject our bill? They
Well,
cannot keep the matter pending. And on the other hand, at the instance of somebody else,
The
respondent number
dismissal
6,
of the writ petition would help the government to display, yeah. What do you call it? Yes, government, who is paying for the government? Yes, who are you? Who are you?
I have filed. But those who have been under order was there. For the order was.
Unnecessary. Don't worry with them.
I am the present chairman. So I am.
Is it?
Yes,
So you are then also, Mr. Professor is using his locus.
so I'm a shareholder. So I have some feelings. The shareholder That's extra.
Now you and it is more like not a petition under order 1 will tell, it will be a petition under order 22 will tell. It's a case of assignment. Anyways, we will make it, there is no worry, but government, yes, madam, Bordloy, tell me, do you grant so much of land? 8 because where is the land sought for? Where are you seeking the land? Yes,
I'm respondent number 6 in item number 28.
don't go by 28, 29. I don't see the list. Tell me where.
And I'm the petitioner in 7977 of 2020.
Kakini Mohumuki
Yes.
SS Limited, yes.
The present fact of the case is that, Lordship, we have purchased the land through liquidation process, Lordship. Previously, they were in that particular land, Lordship. They were in that particular land. We have purchased by virtue of a sale deed, Lordship. Thereafter,
You have
what
purchased from whom?
from through liquidation, Lordship, sale deed is a pays, Lordship, 30.
Of?
Of 7977, Lordship.
In this case, in that case, we are not made party, so we don't know what is their stand, what is their content.
Then
Page number 30, Lordship. Then what had happened, the respondent authorities, Lordship, the respondent authorities directed them to evict the land, Lordship. They are not evicting the land. Thereafter, they are again and again approaching this honorable court, and they are taking the status quo order, and they are 10 to 12 years has already been passed, Lordship. No, till that they have not evicted the land, neither they are paying the rent.
But local thing here, court cannot.
okay, first of all,
On other, earlier,
one Pansu Das wants
Himanshu Das is the shower. And yeah.
some land. Again, it is a something which is covered by tag number 29 under Kaki Moja and regularly paying the rent as land revenue. How are you paying land revenue? Totally. Now, if the land has been now sold to this person,
I'm also
with the respondent number 6.
Yes.
Has been sold to the respondent number 6. Then how can the government grant you allotment?
My lord, kindly appreciate. What is their status? What is their local?
No.
Does it, my lord, it is the government land. Yes,
The government can allot a land which is in their hands.
my lord.
But
Bob-
the land is allotted to them.
Land was never allotted to them.
Was sold to them.
No. Government cannot sell the land. If the government land, how can they, my lord, purchase the land?
No, they have sold it by liquidation. That is what they are saying. Yes.
Page number 30
Of
7977.
That, in that case, we are not made party. We
Yes, you were made 30, respondent number 8.
You didn't serve the notice.
Obviously, we have served it.
No, we didn't receive any notice.
Residents so committee. Purchase a seller, Babul property liquidator cooperative society.
No, no,
And
that is-
along with the existing house standing thereon described in the schedule of this thing.
give us that.
The apartment figure. Who is Kaki Marketing Somawai Committee?
Taki Samaj was the original society, which has become a defunct. And we may not pay the
It's
entire
sold
liability.
To the above mentioned purchaser.
Yes.
For a purchase of rupees 5 lakhs and handed over the possession of the scheduled premises today to the purchaser on receipt of the entire amount. This is done under what provision? This sale?
It is done for liquidation process. Lordship.
Mr. Peter, who would have no case unless you challenge you.
My lord, that copy was not given to us.
What was it really?
That
Anyway,
just have a copy to us.
we- we dismiss your reputation with liberty being given to you to file to challenge this. Without a challenge, you cannot.
Right,
have an election. Because later on you have a.
Today, for the first time, I have come to know that something may not happen in their favor. What has prevented them to serve a copy to us? And my Lord Chairman, he was also, he did not receive any notice.
I'm not concerned with the effect, but the fact that both the matters have been taken together, there are orders to the effect. So it was your duty also to look into it. The matter has been going on for a long time. They've been taken together for a long time, see?
My Lord, better, my Lord, may I suggest, my Lord? Okay, kindly, without fussing in your today, give us 7 days time so that we can make a challenge.
What?
We can make a challenge, my Lord, that thing or all.
Challenge, whatever, what right do you have today?
Otherwise,
What status quo? Status quo is not there.
Hello?
No, your basic casing doesn't exist. And who are you? How can there be a status quo with Himanshu Sekhar? What do you mean? Himanshu Das?
Or anything, my Lord, we did not have any knowledge. And for the first time, we have come to know that there was a regulation of
Apprise you properly. He should have. Anyway, so let Mr.
Okay, can you see the last report?
First, let me dismiss.
Can you see the last report, my Lord?
First, let me dismiss Mr.
My Lord,
Professor
okay,
Mukherjee,
before
and
dismissal.
thereupon,
My Lord.
we give it and ask your committee to come. And what is this person, the one person coming? How can you maintain a institution? It is a public institution. Then why is the society a guilty person? Even the society is a guilty person. Heard Mr. AK Prakash to the limit.
Lord, you kindly appreciate, my Lord. Before, my Lord, passing any order, Lord, you kindly have a look.
Passing it now. Your entire
50. Page 50.
I am agreeing for the purpose of, but first of all, you have lost your locus.
Fine.
Figures. Heard Mr. AK Prakash to the limit. The people who appear in the house of the only one, two, one in the one, two, nine. Two, three, yes. One number 4. It's the term for it's 6 months. Right, that's what we see. We just shareholder an ex-chairman of Guragaon SS Limited had filed the instant petition taking a direction upon the respondents to take necessary steps for allotment of the land measuring 8 bighas 13 meter covered by dark number 29 and the Taki Moja of Unitipuri village in Nagaon district in favor of the same society. And further direct the responding authorities not to disturb the peaceful possession of the people in respect to the said land. It is relevant taking thought that the instant notification was tagged along with the WPC number 7977 by an order dated 28/10/2024. Mr. P. Woodlow, appearing on behalf of the respondent number 6, who is the writ petitioner in WPC number 7977/2024, submits that the entire prayer made by the petitioner had become infructuous, taking into account that by the registered deed of sale, the what is this? This is not a registered document. Huh? What is this type of document? Mr. A.K. Tupac, the Learned Counsel is hearing on behalf of the petitioner submits that the petitioner is unaware of the meetings in WPC number 7977 of 2024, 22, which have been tagged along with the incident proceedings. He therefore submits that respondent number 6, who is the petitioner in WPC number 24, be directed to serve a copy of the petition, which taking into account above the petitioner hearing, the respondent number 6 hearing, who is the petitioner in 24, is directed to serve extra copies of the petition upon the petitioner in the instant proceedings, who is also the respondent number 8 in WPC number 7977 of 2022. List according on 29/11/2024.
And status quo order, madam.
Mr. Pukas, I want. In the case of a civil dispute, we have made it. Tell everybody that this is
Already there is an order, already there.
very well, and be happy with this. And which one? They are not giving it to you. Huh? Yes, Mr. Pukas, why you are not giving a copy of the petition to her?
Pablo,
Yes, next. What is the case?
This case law is that election committee did not follow the election procedure law as per proper procedure law.
Will you file your activity in reply?
No.
You want to file?
No. This case is very much clear, Lord. The respondent authority has not followed the procedure lordship prescribed by the Rule 6 lordship as per the Tata Ministerial District Establishment Service Rule 1967 lordship. Holy lordship, very much clear, Rule 6 lordship. For the purpose of recruitment lordship for the post of head assistant your lordship, subclause 2 lordship clearly mentioned that Sador head assistant, sub-divisional head assistant by selection from among the senior
Okay, we
assistant.
do one thing, we fix this matter on 26th of November for final disposal. This matter on 26th of November, 2024, which the intention to meet to dispose. Okay.
Keep them.
31.
Page 46, in this case, part payment has been made, page 46, page 46.
You got part payment?
Page 46.
Okay.
As per our instructions, the liability is only for rupees 4,93,629.
And how much you have paid?
We have 2,48,000.
Okay, when you are paying the remaining?
Actually, the petitioner has done the work under FMP scheme, and your lordship in FMP scheme, 90% of the 90% of the payment has to be borne by the central government, that is the Ministry of Jal Shakti, and 10% will be paid by the central government. But your
Learned
lordship,
Counsel is hearing on behalf of the water department submits that the contract work which the petitioner had performed, has claimed to have performed is under a scheme of the Ministry of Jal Shakti. Mr. Titular Sravan, the Learned Counsel is hearing on behalf of the petitioner submits that he will take appropriate steps for increasing the Ministry of Jal Shakti. Mr. Please the matter upon filing of such. Because later on, if I pass an order, you will be more in trouble. Wait a minute. Yes, Mr. MJ Borua.
Here, once regularized, right, deputation, then reverted back, his regulation.
Oh, yeah, the government is not filing affidavit.
Last of those.
But on last occasion, the petitioner was asked to bring the order by to which the petitioner was sent on deputy because what the petitioner is relying on is the
Well, then, Mr. MJ Borua, the legal counsel, appearing on behalf of the petitioner, submits that the petitioner have resorted to have taken steps under the provisions of the Right to Information Act 2005. And as such, some more time is required in that regard. List the matter after 4 weeks. In the meantime, the respondent states shall bring on record their stand by filing.
33 and 34.
This matter relates to justice senior of the petitioner in the district justice and commerce department.
Huh?
This is regarding seniority.
Okay, why no affidavit filed?
Okay, it doesn't come to the records.
And in other case,
Fine.
this is another case.
Yes, number two
Yes.
cases.
Two matters.
Both are similar.
Similar, but like the final criticism list was published later on. While the pendency of the matter, so they have challenged that.
Mr. A. Kalika, the legal counsel appearing on behalf of the Industries and Commerce Department of the Government of Assam submits that the affidavit on behalf of the state department have been duly filed today. The same, however, has not come in court. This was matter again on the 13th of December 2024. In the meantime, the petitioner will be at liberty to file reply. It's to advise.
Okay.
55.
But in this case, the petitioner has filed his affidavit in reply, but by mistake, the certificate which has to be enclosed with the affidavit in reply, that certificate lordship will enclose. That may be allowed to file a press case.
File an additional affidavit. What certificate?
Lordship, certificate of technical education first, which is equivalent to lordship class
Sir
12.
T. Sharma, the learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an additional affidavit bringing on record the certificate pertaining to technical education,
Which is equivalent to class 12.
which is equivalent to class 12. So time, 2 weeks' time in this regard is granted.
File your reply.
36.
I'm preparing on behalf of SK Noor Mohammed. In this matter, lordship, we have, they have filed affidavit and we have filed affidavit in reply.
No, nothing is available here.
No, lordship, even I have not received a copy of the reply.
You are saying about table 6075.
6075.
No affidavit is there. No affidavit in opposition has been received. You have not filed affidavit.
Yes, lordship, I know.
Huh?
Yes, lordship.
When?
On 25th of September.
Huh?
5th of September.
Okay. You have filed on 26th of September,
25th of
September 2024.
Yes.
Counsel appearing on behalf of the respondent, Health Department submits that the affidavit has been filed on 25th of September 2024.
On behalf of respondent.
Have you filed any reply?
Yes, lordship. On
The petitioner also submits that affidavit in reply have also been filed. Which the registry shall bring on record such pleadings and list it after 3 weeks.
37.
Time appeal for response number 6. And the author is allowed to give his time for filing affidavit.
Huh?
Give his time for filing affidavit.
What is your case, Mr. Mukta?
The unauthorized construction of a building.
There is the report of a circle officer is very specific, but you can case 20 lakhs.
Because the interim order would be considered today. What is the interim order you are asking?
Order, my lord, admittedly, my lord, it is.
Are you still constructing?
My lord, it is my land. He wants to demolish my building, but anyway.
Are you still constructing? So we hold it that you are not constructing. To maintain status quo as regards construction. Huh? Oh, indeed.
So also I have
Counsel is appearing on behalf of the respondent number 1, 4 and 5 submits that no steps have been taken pursuant to the orders being passed by this court on 13/10/2023. Taking into account the above, the counsel appearing on behalf of the petitioner is directed to serve extra copies of the requisition of the additional senior government executive within 3 days. Mr. K.K. Day, Mr. Swen, the learned counsel appearing on K.K. Day, the learned counsel appearing on behalf of the respondent number 6 and accommodations of finding the reply. This the matter again on
my lord, I
2nd of December 2024. In the meantime, the reply we filed.
sir, I am getting for number 12.
38. No affidavit filed on 11 after 11/11. After 16/9, did you file the affidavit? No.
On
You will not
4/11,
file.
swearing is on 4/11, madam.
Huh?
4/11, swearing, madam, so date of filing. is not
It has been submitted by
4/11.
Ms. Yuda, the learned additional senior government advocate, that the affidavit has been filed on behalf of, affidavit has been filed as directed by the order dated 16/9/2024. However, the same affidavit is not in the court. This could matter again on 6th of December 2024. The registry shall bring on record such a.
In the meantime, I will file.
In the meantime, the petitioner will also be able to file such.
39.
Lordship, in this matter, actually, I was arrested and kept on jail actually of a civil imprisonment case. Substitution allowance.
What do you want?
What happened actually, my
No, what do you
arrest,
want here? Why
my,
are you invoking?
what I want, what I pray for is that the arrest warrant which was issued against me and my arrest conviction is illegal.
No. Why should do this court exercise all these things? This is done by who, under who? Who has done that?
Yeah,
Who has issued this?
this was issued by the Pakija department. I had taken a loan from a city cooperative bank actually.
This one you are challenging page 18.
Yeah, actually, what happened is actually whenever someone is sent to the jail of this one, substitution allowance has to be paid actually because in this Guwahati High Court there was a case actually for civil imprisonment. The rule number order 29. It has been elaborately explained what has to be done.
Have you paid that amount or not?
No, my lord. Actually, I am the one who has gone to jail. They had not paid. When I filed the case and
Have you
after
paid the 15 lakhs or not?
which one?
The 15 lakhs which you are liable to pay?
13 lakhs.
15
13 or
lakhs.
something, yeah. Not yet, my lord.
Have you paid or no?
Not,
Go behind the. Nothing.
no,
The
But I'm-
respondent shall bring on record by filing the affidavit, list the matter after 4 weeks. These type of cases we are not going to entertain unless you pay your dues. Or challenge the Bakidai notice. You are not challenging the Bakidai notice.
40.
You are to pay that 15 lakhs, you have to pay. Yes, what is this? PTC,
Ordered it on passed on 6/9/2024, directing the
it's the matter again.
obtain instruction and to file their affidavit.
Oh, this is a fight between both. of
Yes,
you.
yes, yes, sir.
What has happened?
Easier than that.
Arkin Musari appeared to be clear standing affidavit for vetting.
Who?
Arkin Musari is standing of madam, clear standing for vetting, madam. Unwell, madam, they can come up with that affidavit.
They have been submitted by Mr. Esbora appearing on behalf of the BTC that the affidavit has been sent for vetting and will be filed within 2 weeks. This matter again on 11th of December 2024. In the meantime, the affidavit be filed on behalf of the BTC.
What you are asking is concerned.
Have you made that inquiry which I have asked?
That's the instruction of the affidavit.
Yes, next.
I can put you on.
Praying for some time to file my affidavit.
Then Eka appearing on behalf of the APDCL submits that some time may be granted for filing the affidavit in reply. We seen that on 22/11/2023, this court had granted 4 weeks time for filing. However, no affidavit has been filed. As such, this court fixes this matter on 29th of November 2024. The affidavit in opposition be filed by 27th of November 2024. By the APDC.
I didn't have this 1998. That SLC it was being rejected that due to with no vacancy. So the SLC it has been rejected due to no vacancy.
What case you have? Compassionate appointment.
So the
I think I'm the,
had it been 20 years at 1998, today it would have been at around 50 years old. Last occasion, Lordship, the state respondent was directed to file affidavit. So it's at our letter, but the parents also acted.
when did the father die?
1998.
Yeah.
1998, Lordship.
Why you are here now? How are you surviving?
We have approached just after within 1 month also.
No, understood, but does anything remain in a compassionate appointment now? Is it a right? There are many judgments of this court also. You try your luck with some other court better.
Lordship, we have approached the Court Honorable Court by filing another petition. In that petition, Lordship, at page 31, the order is there, Lordship. In that case, Lordship, the state respondent-
Whatever may be, Mr. Counsel, you don't have a case. 98, you have been able to survive till now. This is not a case of compassionate appointment. Matter is, you have two options, either dismiss and leave the right court for free or wait for another next year.
They won't vote on the one. They won't vote on the other.
Huh?
They won't vote on the one person.
I don't know, there are lots and lots of them. There have been so many judgments on this.
At that time, Lordship, ELC was not there, SLC was not there.
Necessary,
Yeah,
but the fact that you see the compassionate appointment is not a, what do you call, it is not a right. It's not a right. Anyway, don't try your luck today with me. It's the matter after 2 weeks.
Much.
43.
Councillors filed affidavit, but deputy commissioner's affidavit would be necessary only for the purpose of whether the land petitioner's land is within the project area. Because they have given compensation in respect of the mother's land, but in respect of the two other siblings, they have not given the compensation.
this petitioner number one, they have received 2 and 3. They have 25 bighas of land. They made compensation, my lord, your lordship, and paid 37.
Compensation for what?
For the APGCL has, for the purpose of their project, they have required land. And hydroelectric project, but when your lordship look at the map I have given, and within the map there are 25 bighas of land. It belongs to petitioner and their two daughters, son and daughter. They have not divided formally, but the land belongs to them. Ultimately, they have paid for the mother, but the two siblings they have not paid. They are saying it is not within the project or they have not raised the bill. Initially, they have raised the bill and subsequently they have denied. So if the deputy commissioner says, no, it is not within the project area, this contiguous land, other than this.
How can this go to say?
Court cannot say, I understand, my lord. So therefore, only subject to refer what your lordship has said. Then deputy commissioner give a report, my lord, the report.
This is
says
done
no.
under what provision? Acquisition? Under what provision?
Is
Your water resource. What?
Concealed.
Huh?
Concealed.
Demand house. Okay. Done under what provision?
They have not quoted any provision, page 31.
What is this? You have filed affidavit, somebody has filed affidavit 4 and 5. This acquisition is done under what?
4 and 5, they are the,
You are the requiring authority.
if
This acquisition is done under what provision?
these are equal patta land, and the NCS authority, they have given us the amount that is the deposited, and we have deposited. Paragraph 8 of our affidavit says.
Sir, not under what provision this acquisition is made?
But in fact, there is no acquisition process. I think which only the Jirat compensation they have assessed, the NCS authority, they have
Because of inval patta.
the Jirat compensation.
Are
they have
you
assessed.
saying inval patta only zero compensation is given?
That is
He has a right. How do you say this?
4,95,000 has been assessed. The base authority, they are the base authority.
Whatever may be. But the question is not there, but you are taking over the right. Under what provision?
That is the correct.
My goodness, this repetition is pending from 2024. Well. It is in fact very sad for that I am taking bench 4, 5 matters, then also these type of matters are ending like this. On inquiry made upon the learned counsel appearing on behalf of the Dimahasa District Council as well as District Council or Autonomous Council. Autonomous Council as well as the APTC as which the requiring authority. Both the councils are not aware under what provisions the land have been acquired. Because under such circumstances, the councils appearing, they are directed to obtain necessary instructions and make necessary the necessary instructions. So list this matter on 20/11/2024.
Okay, go to 47, also direct deputy commissioner to give a report. No provision has been applied. They have just given a.
Let us get this. Bench 3, my lord. I am taking a civil bench 3. That is what. I was under the impression. The problem therefore arises is that I am taking up all benches. I initially, I also thought that, but now I am being told that I am taking up this. Tell me.
I was on the other. 4 matters is there also. 3 matters regarding the duty and 1 matter regarding the suspensions.
Here lordship, four matter is taken lordship. One matter is in respect of suspension lordship, and another matter is in respect of lordship, the departmental proceeding lordship. Lordship has severely then compared to separate.
Suspension is different. Now, what is this 431?
431 is.
431 is the suspension matter.
How do you suspend him for such a long time?
It was reviewed time to time. It was reviewed time to time. Then also. What had happened is that even was in last week was also gone also.
Now, he was arrested.
Yes.
Now, what has happened thereafter?
I came out on bail. I was kept under team suspension. They reviewed it periodically. Now for the last, then they transferred me from that place, from Ranchi to Jorhat and thereafter to Khatkari. They've kept me out of the place of incidents where the discipline proceedings are going on. They've removed me from there. Even then, I kept for 4 years under suspension at 50% of my allowances.
No. This type of thing.
Since I'm kept here at Khatkari, since I'm under suspension, I have to pay the house rent equivalent to the guest charges, and I have to pay for my food also, which is otherwise not recoverable from this year. This is the suspension is still that extent. Other part,
Did you ask now see the? Four CBI cases pending, other cases are there.
Four CBI cases.
those criminal cases are pending in Jharkhand. I am being posted here at Khatkari. I am away from the place now. Every time I have to travel at 50% of my salary on my substance allowance. That is substance allowance. That is one part. The second part, 4 years of keeping me in suspension for whatever reason. When, my lord, I am away from the case where the incident second, even in cases, sir, my lord, the Honorable Supreme Court has said prolonged suspension need not be continued. We post him somewhere else where he cannot harm anybody, anything. Let him work or complete it.
And what is the allegation against him?
There was some allegation of defalcation of some money.
407, forgery, 468, 471, 419, criminal breach of freedom, 420. What else is required?
All money.
The thing is, when they have started,
All money.
the allegation in simple lines, the allegation is that they say that I had used government, what they call as security money, what the commandant has some money that is disposal to meeting to the internal security affairs, for which he does not have to give any, what to say, he doesn't have to account for it. It is used for internal security.
You think that judgment of the Supreme Court in Ajoy Chaudhary, there is another big Indian judgment of Justice Departmental also. Will you think?
That I'm
There is one judgment of mine. What is the name? I forgot. Some similar name person. What was his name? The change of the appeal on suspension. How it is be done. And the Supreme Court had mentioned about that judgment of the Supreme Court. Wherein the Supreme Court says that means what was happening in view of certain judgment being passed, the law declared by the Supreme Court in Ajoy Chaudhary was getting a bit, the efficacy was lost, but this was again reiterated in that 2020. I delivered a judgment on this. I forgot. This was the Karimganj.
Also said delivered two judgments. One is in respect of the elementary division, one in respect of the lawsuit higher division. Also the detailed judgment is there.
No. This is in respect to that Karimganj police recruitment case.
Yeah.
There are two persons of the same name. That's a very, he was the additional SP or something. And his name is Prokhanto. Yes, because he's
Prokhanto
and that retired DICP or DIC's name was same. Prokhanto Dotto. Yes, you see that there I have dealt with it. And I think later on, Justice Nair also has followed that. No, the way recent last month or one, it's all another. Because the question of prolonged suspension has a lot of ramifications. Like
somewhere
he only says that I am a temporary bench. Why should I take it?
No, that is what we had what discussed. So, that is never the case. We are ready to.
When do you want? Because I think you need to segregate the matters. Because if you don't segregate, your suspension will always be tagged with the disciplinary. And disciplinary is on a different pedestal from suspension.
The disciplinary proceedings was at a stage of the inquiry, ex parte inquiry report, where my stand was that I was under medical treatment for mental illness, which was in their knowledge. Yet the proceedings proceeded. My case in the disciplinary proceedings part is that I should have been allowed to participate in proceedings, given a chance of cross, because the statements are there. A chance of cross-examination, a chance of my defense. Then prepare the inquiry report. That will suffice my grievance regarding the disciplinary proceeding. So now there is an order from the Supreme Court that they would not pass any penalty order on the inquiry report if the matter is filed. So far as the suspension is concerned,
If we dispose of that, this will also go.
then the suspension,
The suspension will be taken care of.
but even then, my lord, because of the, if they are allowed to proceed with the disciplinary proceeding, they will be allowed, they will proceed. Again, during that entire time, I'll be under suspension. I'll be kept under suspension because without, even when there is a stay on the disciplinary proceeding, I'm still under suspension. And the
No,
proceedings are
what
not,
do you want? Have you submitted your statement of defense?
they have submitted an inquiry report. So he was conducted, was it, yes, report was received by the, everything done. I was in, the final discussion. If the inquiry report has come, and it is that stage, I prayed for them that give me a chance of participating in the inquiry because I could not participate because I was hospitalized or I was under medical treatment, outpatient, whatever.
So therefore, the inquiry report has to go.
Inquiry report has to go and I must be given a chance to participate.
That is
That
what.
is all.
So once the inquiry report comes, then it will take care of your suspension. Yes. If it is being directed to do it within 4 months, I think that is the best option.
That would also.
Yes. Then it would be easier, it would be faster. Yes. Then your suspension also is being taken care. If tomorrow the inquiry report comes up and finds that no, you are guilty, then the question of suspension becomes useless. The petition, it will become infractions. And on the other hand, if it says that no, you are exonerated, it matters. But the same issues are pending. Anyway, this matter, when do you want?
We got 10 days later.
Okay, so the request for proposal, the matter is being reviewed to the next 28th of November. Wait. I can get it done.
Yes, ma'am. My pleasure.
Yes.
I'm able to respond.
You're not filing affidavit.
I'm fine.
The HSAK appearing on behalf of respondent number
Six.
6. I mean that he may be given some time to file the affidavit. It also noticed that the respondent, the other respondents have also not brought on record their stand by filing. This is again to 9th of December. In the meantime, the state respondents as well as Mr.
they are-
private respondents, we find that.
In their opinion, my friend has already taken time, madam.
Even a date, they would matter knowledge.
Tell you, obligatory.
Affidavit file. Oh, this is a very serious issue.
Yes, definitely.
Because I have asked you to file an affidavit on 89 and he said that affidavit is ready and the same is being sent for vetting. And therefore I filed the affidavit on 410. So we asked this person to appear. Who is he? Who is to appear in that matter? Huh? No. We are seek the appearance of the person concerned. Who is that? No, nothing doing. Okay, we have it the matter again on Wednesday. So bring your affidavit by tomorrow. Please, otherwise it is the case. No, nothing doing. You can't be so doing. Or we ask the person. Read that affidavit, the district administration. This court, it takes note of that by the order dated 21/8/2024, 18/9/2024, specific directions have been given to the district administration to file the affidavit. However, no affidavit has been filed. In fact, on the last occasion, which is almost No, it should more than a month. Well, in fact, on the last occasion, that is on 18/9/2024, the government advocate had submitted to the district administration. Submitted that the affidavit is ready and the same had been sent for vetting. Under such circumstances, this court finds no reason why such affidavit has not been filed. Accordingly, it lists this matter again on 14th of November 2024. It is made clear if the affidavit is not filed on or before the next date, this court would be constrained to seek the personal appearance. Mr. Borua, he imposed a cost of 10,000. Hey, come on. No. This is not.
Actually, the instruction I am having, Lordship,
No, absolutely no.
sufficient for, Lordship, kindly, Lordship.
Taking into account the above, it seems that the various orders passed by this court have been disregarded. Accordingly, this court grants the district administration time to file affidavit by 27th of November 2024. Further to that, this court imposes a cost upon the district administration. Which one?
Secretary of the Revenue Department. No. Deputy Commissioner,
District Commissioner, Golaghat, the district administration of Golaghat, a cost of rupees 10,000 to be deposited at the, before the registry at the time of filing of this, of the.
This is regarding non-payment of arrears salary with effect from 1/4/2023 till date.
What is this?
Lordship, I have some instruction, Lordship.
Very good.
District, Social Welfare Department, Lordship.
Area salary,
Yes.
why you are not paying?
Lordship, this is the honorary service, Lordship. Due to certain issues, Lordship, something has happened. And I have got an instruction that already steps have been taken, Lordship.
Or-
For payment of the arrears salary, Lordship.
Miss so-and-so appearing on behalf of the Social Welfare Department submits that some steps have been taken for the purpose of payment of the
Arrears salaries, Lordship.
payment of the amounts due to the petitioner to succeed, therefore submit sometime may be
Yes,
granted.
1 week time, Lordship. I will provide the instruction.
Second of November 2024 for an update.
Deeply obliged, Your Lordship.
Give your dates.
Deeply obliged.
Find my affidavit, Lordship, and similar measure fixed on 23rd of January.
Miss B. Sharma, appearing on behalf of the respondent submits that the respondents would be filing an affidavit in the matter. Also taking into account as well, this matter again on
Similar measure, Lordship fixed
8th of January 2025. In the meantime, the affidavit will be filed. Yes.
My lord, it's like they got week time to find out, really, my lord, it's like it's like it's no before my lord. And maybe on the other, number 3, 4, and 5. They're directed to find the affidavit. The as well as the asking for 6 also was directed to find the affidavit.
We have made a specific order, madam. What is wrong with your date? Very serious issue. We have asked you because the question which is involved is once the deputy commissioner fixes, can he review it? That's the question. Like in the land acquisition proceeding, there is a power of review. The review power, I don't think is there here. Then why you are doing it? You withdraw that. Why you are doing this? Miss Yuda, the Lennox senior government, additional senior government advocate submits that he that the affidavit in terms with the directions passed by this court on 9/9/2024 could not be filed. It therefore submits that 2 weeks' time may be granted to find the said affidavit. This the matter again on 29th of November 2024. It will be filed by the respondents, including the Power Grid. Power Grid. Power Grid is the respond number.
344 and 5.
The affidavit be filed by all the respondents on or before 27th of November.
One additional affidavit was filed annexing the relevant documents, which is not attached to the record. Additional affidavit was filed by the petitioner, which is not attached to the record here.
That has not come to the record.
Let me get down and go to the registry and get it. Then
53.
yes,
My lord, I have received the instruction, my lord, lordship directed to file the affidavit. May I say, my lord,
we will file the affidavit. However, no affidavits have been filed in spite of clear and categorical directions. The learned counsel appearing on behalf of both the district administration and the PWD had sought for time again. For the interest of justice, this court grants time to 2011-2024 to file the affidavits on behalf of the district administration and PWD, failing which it is made clear this court shall dispose of the petition on the basis of this court shall presume that the respondents herein have no objection to this, failing which it is made clear that if the affidavits are not filed on or before 2011, on or before 18/11/2024, the instant petition shall be disposed of on the basis of the materials already available on the court.
This is also not non-permanent of year salary.
This day, 2011, asking them to file the affidavit. Yes, what is this?
Yes, this is my lord non-permanent of period salary, my lord. Since my lord, October 2023 to February 24 and June and.
Why you are not paying?
Copy has not been served here. Copy has not been. We have not received.
The council appearing on behalf of the state respondents submits that the copies, the additional copies of the petition has not been served, taking into account the above, is the matter of the 4 weeks. Mr. Council, you are not helping your.
Copy has been served, my lord. Copy has
No,
been
you
served.
said they're not.
It's able from the record. Madam. 55 and 56.
What are these matters, madam?
These matters are regarding that land's compensation, it's a diminishing value of land.
What are you challenging it?
I'm challenging the order of the district judge by which he gave the
So we
diminishing
dismiss
value
it.
of land.
We dismiss it.
The lordship had already passed an order.
No, that that point of time is different, but this is how are you maintaining order of the district judge in a week?
Lordship, because under the Telephone Act, there's no provision.
227. Not 226,
Lordship,
not 226.
but this is a miscase, Lordship. There's a miscase, by error, he gave the value on diminishing.
Understood, madam,
Yes.
but the question is, it can order passed by the civil court.
Lordship, I already dealt with this
No.
similar matter.
I become law clever after 2 years.
Lordship, this is also remanding back, Lordship, the same thing, series of petitions have been.
Who is appearing for the other side?
Lordship, they have not
Oh,
appeared,
service
sir.
upon air is complete.
Yes. The last part, Lordship. I don't gain lots of my, in effect, the matter has just been remanded back.
So we'll change the number, no? Remaining is same.
Yes, Lordship.
Present case has been filed challenging the order if they pass in one. And there is. Lemon. So it's same, everything is same.
Everything same, even the land is adjacent.
No, not only that. The service upon response number two being not complete, that is, being complete is also same. It also- Anyways, you can dispose for debate.
So we both are same.
Disposed. Order to silence, huh?
P7 and 58.
Has been deemed service hetu also, so. Yes, what is this?
Wait, please allow. My lord, I will be allowed to take steps so far as number 4 is concerned.
Mr. Health Doctor, the senior counsel submits that he be permitted to take fresh steps upon the respondent number 4 in WPC number 7362 of the 2018. In the other one, there is an affidavit filed by respondent number 1.
Yes.
So it is only 7360.
Exactly.
According to this, the petitioner is directed to take steps by way of register as well as review. Respondent number 4 with the 7 years.
Right. Denied.
Yes, note the steps taken upon the respondent number 4. Okay, none appears on behalf of the petitioner on call. It is further seen that Mr. S.R. Purva appearing on behalf of the state also submits that extra copies of the writ petition has also not been served. In addition to that, the Lordina Court's order also reveals that the steps have not been taken insofar as the respondent number 4. The above therefore say that the petitioner have lost interest in the instant proceedings. Accordingly, the writ petition stands dismissed for non-prosecution.
60.
Same. Same order, same,
Whole matter, the direction,
same way, same.
direction. Not direct settlement. But the matter,
Direct.
because they were asking.
Yeah,
They're
they
all
will
direct.
dismiss for non-prosecution. And not taking steps. It is the same, 16 same, no? There is a respondent number 4, Mr. Sharma. Did you get a copy?
Sure, whole matter.
Let me see.
For 4 is not there.
Item number 62. Just 1 minute. Otherwise, it's remain the same, but otherwise it's.
We have settled it. After it was a direct settlement also. That was appellate matter.
After you came, the things became better in AFDC. This is AFDC. Okay.
That matter
Mr.
is
Nan
after
appears
the
on
Supreme
behalf
Court.
of the petitioner on call. Yes, Mr. P. Sharma appears on behalf of the respondents in the fishery AFDC. AFDC. Yes, sir. The record reveals that the petitioner was directed to take steps upon the respondent number 4 by way of registered post. However, the various orders passed by the Lordina Court shows that no steps in that regard was taken. In addition to that, the learned counsel appearing on behalf of the fishery AFDC further submits that these fishery in question have already been settled by floating NI. Taking into account the above, seems that the petitioner have lost interest in the instant proceedings, and accordingly, the petition stands dismissed for non-prosecution.
61.
applicable. My lord, order dated 5/8/2023 is yet to be complied with, my lord. Kindly see page 17 operating part. my lord. There are 30.
There was a direction to pass a reasoned order.
After the single bench order, we have preferred the appeal, my lord, which was dismissed. Thereafter, we filed SLP, my lord, for the apex court.
That was also
Although
dismissed.
apex court was dismissed, but liberty was given to us, my lord, for the higher for clarification of the dismissal order. Thereafter, now we have filed it.
Then why you are not passing the order, reasoned order?
My lord,
There was
after,
a direction to pass a reasoned order within a period of 2 months.
my lord, except that business bench clarification, my lord, we cannot pass it. That is the technical problem. Because the date of.
File an affidavit to the effect.
Yes, lordship.
Why you are not in a position to
Grant, yes, grant 2 weeks, I maybe.
You have been earlier given 3 weeks. We impose the cost of,
IA is not numbered, my lord. That is why we have waited.
we impose the cost of 30,000
This time, lordship,
cost.
only 2 weeks. Only.
It is seen that no affidavit has been filed on behalf of the respondents in spite of various opportunities being granted. This court made a specific query upon the learned counsel appearing on behalf of the respondent number 1. 1, na? 1, 2.
1 to 3 of pay energy, my lord.
Huh?
1 to 3 all of pay energy.
No, maybe the respond number. You are paying for whom?
1 and 2, I want.
On behalf of the respond number 2, as to
I can
why
remember.
no order has been passed. Comply with the directions passed by this court on 5/8/2022. The learned counsel submitted that in view of an application being filed before the learned division bench of this court seeking clarification, the order could not be passed. This court fixes this matter again on 18th of November 2024. The respondent number 1 and 2 are directed to bring on record their stand by filing the affidavit.
Because 2 already expired.
So what?
I'll file.
You were appearing for one or two, whatever may be, you filed it.
Hello.
Kindly oblige, your lord.
18th, huh? Affidavit filed, 18th. What is this, 2000?
Matter is a dispute between management and water. The erstwhile Assam State Textile Corporation. So the deferred tribunal had in the favor of the workers. Against that, my lord, ASPC, my lord, preferred this writ petition. During the
Oh,
pendency.
you want to be party, na?
Yes, that, my lord wanted to know the mode of acquisition.
Ah,
Yes, we could create a pull of some documents, madam. We need some more time, madam.
okay. Mr.
Yes,
Mr.
sir.
Esdas appearing on behalf of the applicant seeks more time to provide instructions to apply this law as to how the AIDC had taken over the assets and liabilities of Assam State Textile Corporation. List this matter. Are you suffering? List this matter again on 18th of November, 22nd of November.
53.
Hmm. Who is appearing for all? Are all the respondents appearing?
I'm appealing for explanation.
7 is okay, na? Okay, everybody is represented. Oh, yes, yes, yes. How is it permissible? Who is paying for that particular government the body? Huh? Municipal, Borpeta Municipal Board. Who is paying? Yes, how are you constructing?
Some time for
Tomorrow,
one.
don't construct further. You have already constructed. It's a case of demolition. Huh? The council appearing on behalf of the respondent number 7 submits. Have you effected the service upon respondent number 2, 3, and 6? Have you filed an affidavit? Huh? No, you have not filed the affidavit. So that affidavit is not here, na? You have not filed the affidavit for dusty service. They have been submitted by Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. That the dusty service have been duly effected and an affidavit in that regard has been filed. So, Mr. So-and-so appearing on behalf of the respondent number 7 submits that we require some time for bringing on record the state stand of the respondent number 7. This is matter on 27th of November. In the meantime, the affidavit will be filed by 25th of November.
Can you put before 27? Can you report 27?
The registry shall bring on record the affidavit of the justice.
You are in 72.
Complied.
Order has been complied. Respondent number 1 has been, respondent number 1 has complied the order.
What are these orders for?
For land compensation.
You paid.
Yes,
Why haven't you filed the affidavit?
yeah.
Okay, we import 10,000. We paid to against each petitioner. How many petitioners are there?
Sometime maybe 100.
28. Okay. Pay 2,90,000. 2,90,000. Cost.
I'm for respondent number 1.
Can you pay the compensation or not?
Compensation you can pay.
I'm not concerned with other things. You pay the compensation or not? What is the direction? On the other hand, if the conclusion arrives that is that the land of the included in the construction which is the we provide that the conclusion is that the land. Very difficult to understand. this is matter of 3 weeks. In the meantime, it will be filed by the response.
Okay.